Your Lordship. Uh,
Again mentioning today.
no, because I am mentioning this matter, item number 54 of today's list. This matter is relating to the matter is Setara Begum, that is MAT 1543. I did not mention this matter yesterday because of the matter was appeared before the Honorable Division Bench, and the interim order in this matter in item number 54 is going to expire on 22nd of this week, and the interim order in Setara Begum has been extended till November 2025 by the Honorable Division Bench. For this reason, I am mentioning this matter because tomorrow is the last date for taken up group 8 by your lordship.
Tomorrow.
Wednesday, Thursday and Friday is the
Group 1 matter. So it was extended till
take it up tomorrow
22.
22nd.
Come on, 25.
21st.
25.
The interim order will expire in them.
Yes. Thereafter Saturday and Sunday.
Yes, my lord.
25 I can pass the order. Item number?
Item number 54, your lordship. Kindly take it up tomorrow. It will not take more than 1 minute.
No. Item number 54.
54.
Item number 54. Today this matter can be taken up. Why are you mentioning this? Today this matter can be taken up.
As your lordship.
Yes.
My lord, similar, my lord, item number 56, my lord. My lord, today, my lord, what I am apprehending, my lord, so many fixed matters are there. And my lord, this.
What are the fixed matters?
My lord,
2
10
p.m. matter, 3 p.m. matter, first half it would be taken up.
First, my lord, if
Yes.
that doesn't reach, my lord, may I come back, my lord?
But 2 p.m. matter, 1:30 matter.
My lord, if that doesn't come, then my lord, I shall again visit
Yes.
your lordship. Leave, lord.
Item number, my lord, 188 of your lordship's list, my lord. This is a contempt application which is appearing for the first time, my lord. So if your lordship kindly give some precedence because of the fact, my lord, this is a group 7.
188.
188, my lord. This is a group 7 matter wherein your lordship are directed to issue permit in favor of the petitioner, but the petitioner cannot ply his vehicle because the RTA Kolkata is not issuing permit, even after providing opportunity of hearing, my lord. If your lordship gives some precedence, my lord.
Whether
180.
they have taken a decision?
Nothing, my lord.
Okay. Contempt application কালকে দিয়ে দেবেন কালকে contempt application first হয়ে mention matter দেবেন না কালকে
Grateful.
May I be permitted to mention before your lordship, I am praying for extension of this interim order, my lord.
today is not the day of mentioning, come on tomorrow.
May I permit to mention a matter for correction and order?
Tomorrow call the list.
For the petition.
For the statement led by Mr. Dutt.
This may be the silence. Well, a vacancy for fair price shop has been notified on 21st of April 2023 under
Yes.
2013 control order. And I applied for, my lord. Inquiry has been conducted. I was found the best suitable candidate. Then I have been called for in the district level selection committee for interview. Then further inquiry has been conducted. Again, I have found, my lord, the most suitable candidate. Then an offer letter has been issued. If you will also kindly turn to page 28,
Offer letter was issued in favor of you.
my lord, page 28.
Yes.
This is kindly see the date, 5th of December 2024. Left hand side top offer letter.
Yes.
Second paragraph, I have been directed to deposit 25,000 as security money.
Offer letter 5th of December 2024.
My lord.
Yes.
Then second paragraph of the letter, you are therefore directed to deposit the 25,000 as security money
Security deposit.
and 10,000 license. We have deposited, license
Yes.
has been granted. If you will also kindly turn to page 29. Kindly see license Oshima Mondol. Bottom portion, date of issue of license 7 January 2025, 31st December, valid. I will also got my lord. Last line, page 29.
29.
License has been issued. Bottom date of issue of license 7th of January
Yes.
and validity up to 31st of December.
Yes.
Now kindly turn to my lord, next page. Who is my licensing authority? This is from 7 January 2025, subdivision controller, food and supplies, Kontai.
Yes.
Now what happened? I have been given the distribution. It starts from page 31. All the delivery orders I have annexed. Then I have distribute the ration articles to the consumers. That will start from page 37 online, 37, 38, 39.
Yes.
Then, my lord, an inquiry has been conducted by the subdivisional controller Contai on 11th of April 2025, along with inspectors who were not the part and parcel of the inspection which was conducted subsequent to my application. An inquiry has been conducted and they found whatever I have submitted, whatever documents placed, all are correct. So a report has been submitted. Now, all on a sudden, I received a communication. Kindly turn to my lord, page 42. Now, this is dated 20th May 2024, issued by the district controller, addressing to the subdivisional controller, and bottom portion copy has been handed over to me, Oshima Mondol, petitioner before lordship. Well, kindly see, re-inquiry against issuance of fair price shop license to renew newly appointed FPS dealer, Mrs. Oshima Mondol in Dokhin Murshidabad under Bhutnia Gram Panchayat in the Beswa block Swanso. Reference E-file number Swanso, dated, date is not there. As per instruction of Principal Secretary, kindly take note of. Food and Supplies Department, dated 20th May 2025, you are directed to conduct a discrete inquiry into the above said subject within 25th May 2025. Positively and submit report to the undersigned within 27th May 2025 for onward submission to the department by 31st May 2025. South of the Subhadev Rai attached to the establishment, that is attached to the district controller, will assist you for conducting inquiry. Kindly see who has been addressed. Subdivisional controller Tomlu. My licensing authority is Contai. Subdivisional controller Contai, I have shown to your lordship for my license. So another subdivisional controller has been assigned the job to conduct inquiry. And kindly see the bottom portion 3. Mrs. Oshima Mandal, care of Kalipata Mandal, so Contai Purva Mednipur. She is directed to remain present at the time of inquiry. No date, no time. When the inquiry will be conducted, at what time, that has not been mentioned. Then a certain inquiry has been conducted, no show cause, no reply, no opportunity of hearing, termination letter. The very next page. 8th August 2025, order of termination of fair price shop license. Kindly take note of, whereas a new fair price shop dealership at Dokhin Murbania, central location near Swanso, Shishu Shikha Kondo, against vacancy number Swanso, in connection with notification number dated 22nd of March 2023, has been approved by the prescribed authority on 17 September 2024. After due inquiry along with other relevant formalities, kindly take note of, in favor of one applicant, namely Oshima Mandal, petitioner before lordship, care of Swanso, Kaltai Swanso, Purva Mednipur Swanso. Offer letter has been issued on 5th December. License has been issued on 7th January. Filed license number Swanso. Then, whereas a complaint from Tahimina Khatun, this has never been supplied to me. I have no knowledge about such complaint. Asghar Hossain, wife of Swanso, input coastal Swanso, dated 26th of March 2025, addressed to the Honorable Chief Minister, alleging that the person who has been awarded new fair price shop dealership at Dokhin Mondabara does not possess legal documentation. The complaint, even if that is that the legal documents in respect of my proper land is not been supplied by me. Then, whereas the report submitted by the licensing authority dated 11th April 2025, who is the licensing authority? Kindly come to the next page. Subdivisional Controller Food and Supplies Contai. Dated Swanso, regarding the above mentioned allegation while unsatisfactory. The subdivisional controller himself conducted inquiry. Now he is saying his report is unsatisfactory. Licensing authority who terminated my license, he conducted an inquiry along with other officials and submitted a report that everything is all right. Now he is saying my report is unsatisfactory. Purva Mednipur Swanso to cause a thorough inquiry in this regard. So, subdivisional controller, another subdivisional controller, Tomluk, has been inquired into. The person concerned who is terminating my license, one again I am repeating, my lord, he conducted an inquiry, he became satisfied and submitted a report. Subsequently, he says, no, my report is not satisfactory. So there should be a fresh inquiry by another subdivisional controller. Now, whereas subdivisional food and supply Tomluk, he is another one, conducted an inquiry regarding the subject matter, and in this report, He has mentioned in detail some serious discrepancies between the physical godown and the inquiry report submitted by the inquiry officer during vacancy inquiry. Hence, the month of August 20, the major discrepancy arise. Complaint legal documentation has not been done. Report by another subdivisional controller, discrepancies in the area. Kindly take note of paragraph 1. The inquiry report as submitted by the inquiry officer during vacancy inquiry done in the month of August 2023 does not mention the fact that the proposed godown is a residential house with major issue of access to first floor through the cell area, which makes the godown not suitable. I have brought all the pictures. I shall show to your lordship. During physical inquiry and measurement on 30th May 2025 by the Council, it was found that the premises offered by Srimati Ashwa Mandal is proposed fair price shop godown has 2 proper rooms. Kindly take note of 24.25 which appears by Srimati Ashwa Mandal as proposed APS godown has 2 proper rooms with approval of 266.75 square foot, which can be treated as godown. There is total 283 square feet of area in the veranda, which cannot be considered for storage of cell area because of pressure of staircase. There is 1 proper room, 1.15 so and so square foot can only be considered as the area. The room 3 mentioned in the inquiry report was physically found to be dimension so and so 161 square foot, not fit for storage of food grains and should not have been considered as godown space during inspection. Thus, the area of the proposed shop become approx so and so, cell counter becomes so and so, which does not conform the godown specification as laid down in the gazette notification. But if this 3 godown shop room takes notes of, it will come down, my lord, 566.65 square feet. Requirement is 300 square feet and 100 square feet in the panchayat area. It comes down, my lord, 566.65. Now, the inquiry report dated so and so transpires that the approved candidate Ashima Mandal shop cum godown was put up to the mark of eligibility as laid down in the vacancy notification dated 20th March 2023. The complainant Tasmina Khatun shop found happiness shall notification of the so and so come is also incomplete residential house with building so and so. And therefore, the fair price of dealership Ashima Mandal hereby terminated on the grounds for selection process based on erroneous inquiry report as submitted by the inquiry officer with immediate effect, and the said vacancy will be notified in the so and so. Subdivisional controller conduct inquiry. Report has been submitted by before the district level shop selection committee. Fresh inquiry has been conducted. File has been forwarded to the directorate. It has been approved. Secretary also approved it. License has been granted. Next inquiry has been conducted by the inquiry officer. That is the Pontai subdivisional controller. Now the subdivisional controller, as if sitting in appeal, submitted a report which has been accepted by the subdivisional controller Pontai, nullifying his own report. No show cause, no opportunity of hearing, no reply. Carrying instance of violation of principle of natural justice. Termination straightway. I have not been intimated what is the charge against me. I have not been supplied the copy of the complaint. What is the complaint against me? Inquiry, termination. Your Lordship knows, my lord, there are judgments. Your Lordship also delivered number of judgments. I am relying on one judgment passed by your Lordship. Khurshid Alam Khan, patron point. Mr. Sagar Bandhopadhyay appeared in this matter. Kindly come to page 3. What was the submission of Mr. Bandhopadhyay? Submission has been recorded at page 2. Mr. Bandhopadhyay, learned senior counsel, for the in support of his contention. Third paragraph. In support of his contention, Mr. Bandhopadhyay, learned senior counsel, cited 3 decisions of this honorable court. Mr. Bandhopadhyay further submitted. I do not go through the entire judgment. These are the 3 judgments he has placed. Now, your Lordship, kindly come to page 13. Your Lordship consideration. After relying on all those judgments, discussing all the judgments, page 13. Findings. May I read my page 13? Yes. I can understand the argument on behalf of the state authority that the present petitioner has adopted fraud practice upon the state authority by showing false and fabricated documents. Well, this is not a case of fraud, so far I am concerned. I am in a better position. But still then, when a license was issued in favor of the petitioner, kindly take note of, the licensing authority had no option but to proceed to take action against the errant licensee holder according to the procedure as established in the control order. Personal hearing notice dated 4th March 2024 and the improved order of subdivisional control dated so and so is appears to be not according to the procedure established in clause 24 of the control order so and so, barred in the provision the same is barred was set aside. In my opinion, statutory authority has to take an independent view and shall apply his own mind, independent view and own mind. Before taking a decision, in the instant case, it appears from the note personal bearing as well as the improved order of concerned subdivisional controller that he has acted in terms of the direction of the higher authority. The improved order itself is not reflected the application of mind of the concerned subdivisional controller food and supplies. Hence, it is bad in law. Under the above observation, I find justification to entertain the instant writ petition. The improved notice personal hearing so and so. In this case, my hearing has been provided, as well as improved order dated so and so, and subsequent order by the concerned appellate authority is quashed and set aside. The concerned authority is directed to reinstate the petitioner as licensee and allow him to continue the business. I make it clear that finding so and so. So, my lord, this is a case where my lord, show cause has been issued, opportunity of hearings, even then your lordship will dictate order. I have shown to your lordship, principal secretary intimated the district controller cause an inquiry. And on the basis of that, district controller directed the subdivisional controller to conduct an inquiry. Well, district controller is my appellate authority. Kindly take note of. But another judgment I shall show before your lordship, my lord. So far the present provision of the controller is concerned. Okay. Penal action, the page 45 with second paragraph, licensing authority. This portion, by the way. What is the provision presented? I am reading from page 45, second paragraph. The licensing authority. Have you also got me? Page 45.
Yes.
The licensing authority may, after giving an opportunity of being heard to the dealer, and for the reasons to be recorded in writing, impose penalty according to the gravity of the offense so and so.
You are reading page 45.
45, second paragraph. It starts from page 44, offense and penalties. Then page after Roman 7, the paragraph starts the licensing authority. Have you also got me?
The licensing authority on a complaint.
No. I am reading page 45, only this portion. First Roman 7, then the licensing authority may, after giving an opportunity.
Yes, yes.
So, opportunity of hearing is mandate. No show cause, no reply, no opportunity of hearing. Now, this has been clarified by the division bench in a judgment filed by the association. If you also kindly take note of this, that no, this is also not suffice. The principle of natural justice must be provided. No, it's a copy as a question. No,
Yes.
Well, kindly come to paragraph 5 and 6 first. Paragraph 6 and 7, page 2. Paragraph 6, I am reading page 2. In exercise of such power, the state of West Bengal passed the aforesaid control order 2024. The writ petitioner aggrieved by several provisions of the control order. One particular provision that the learned single judge found fault with at an interim stage of admission of the writ petition was chapter 9 thereof concerning penalties. Well, I have shown to be your lordship chapter 9. The learned single judge was so and so. Then kindly come to my lord, paragraph 13 at page 4. No, paragraph 13.
Yes.
Paragraph 30 at page 4, my lord. Mr. So-and-so has referred to central control orders, to earlier control orders of 2013, which laid some procedures and refuges to the before the penalties and imposed by Mr. So-and-so. Further submits that the omission of the aforesaid safeguards mentioned in 2003 and 2013 control order from the year 2024 control order is irrational and arbitrary. He also submits that the omission is aimed at giving uncanalized draconian power to the person entrusted with the implementing of the control order. He therefore submits that the implementing order calls for no interference at this stage. Kindly come to paragraph 15. And then, my lord, paragraph next straightway kindly come to my lord, page 6, paragraph 22. Page 6, paragraph 22. This court records the assurance of the learned Advocate General for the state that the principle of natural justice would be duly complied with and followed while applying penalty provisions to the fair play of dealers. It is made clear that the state shall not be prevented from making any changes and or amendments or modification to the control order of so and so as it may deem fit and proper to ensure that the conformity of the similar subordinate legislations already framed by the state and other so and so. So, not only opportunity of hearing, division bench came to a conclusion principle of natural justice, which includes issuance of show cause notice, submission of reply. I don't have any idea what is the offense against me. Copy of the complaint has not been given to me, and the strength of the order passed by the principal secretary, highest authority, on the basis of a complaint, fresh inquiry by the licensing authority, then another inquiry by another subdivisional controller. And the findings of the licensing secretary, my report is not satisfactory. Report submitted by a coordinate officer is satisfactory. But this is not the higher authority also. It is an entirely case where on the basis of the dictation of the state principal secretary it has been done. I shall rely upon a judgment of this court. 2011 volume 5 Supreme Court cases, page 2011, page 1 also. Joint Action Committee, AIR. Kindly take note of paragraph 26, 27, and 28. I'm handing over the judgment. 3 paragraphs. Even the higher authority cannot interfere with. 26, 27, 28. I'm reading my paragraph 26 first. The statutory rules, have you also got it?
Yes.
That statutory rules clearly stipulates that the inquiry could be initiated either by the CMD, CIL, or by the CMD of the subsidiary company in the first round of litigation, and learned single judge of this all court, by judgment and order dated so after quashing the orders into therein, had given liberty to the appellants to start the proceedings, giving adequate opportunity to the division bench.
Dictation.
My lord, dismiss or appeal. Therefore, the question does not arise as to what is the meaning of de novo inquiry. There can be no quarrel with the settled legal proposition that the disciplinary proceedings commence on. Possibly, my lord. Judgment. Just a minute, my lord. Paragraph possibly I am not. Paragraph Eviction. Must just one minute, brother. This is an online copy. Just a minute, my lord. Just. Wait, Anishina. It says, my lord, that even the higher authority cannot interfere with the person concerned who has been entrusted a job. He can only take a decision without being influenced by any official.
28.
Not paragraph 28. Sorry, my lord. I'm extremely sorry, my lord.
In view of the above.
Paragraph 28. Sure.
In view of the above.
Paragraph 28. I mean, the High Court had given liberty.
Paragraph 28. In view.
Paragraph 28.
In view of the above. It starts with.
Yes.
কোন কপিটা দিয়েছে আপনাকে?
Paragraph 28. In view of the above,
Hey,
legal
hey,
voice
hey,
and
hey,
emerges from the authority.
May I read, my lord?
In view of the above.
In view of the above,
The legal position
the legal position.
emerges.
May
May I read?
Yes.
In view of the above, the legal position emerges
that the authority who has been vested with the power to exercise its discretion alone can pass the order. Even a senior official cannot provide for any guideline or direction to the authority under the statute to act in a particular manner.
Next.
It cannot be said that the circular dated such and such was either issued illegally or without any authority. Admittedly, DGCA is competent to issue the special direction and the same had been issued by him, though maybe with the consultation with some other authorities. However, it cannot be denied that DGCA was involved in the process. The authority which had been in consultation with the DGCA had been provided for under the business rules, and it cannot be held by any stretch of imagination that the Ministry of Civil Aviation is not an authority concerned with the safety measures involved herein. The authority are competent to issue the said regulation. Exercise of the power is always deferable to, of course, the power and must be considered in conjunction with it. In view of the above fact that the source of power exists, there is no occasion of the court to link with the exercise of the power to other sources which may evaluate the exercise of the power.
So, my lord, it says, my lord, the person concerned who has been entrusted the job, he can only do his job. Even the higher official cannot interfere. In this case, admitted position is that the principal secretary directed the district controller to conduct an inquiry by a person who is not the licensing authority. Although, my lord, licensing authority conducted inquiry satisfied himself, subsequently another inquiry has been conducted, not at the instance of the licensing authority, at the instance of the district controller. I have shown to your lordship, my lord, page 1 second, I am relying upon. Just I am listening to your lordship. The notice which has been issued to me, kindly see, district controller issued at page 42. Re-inquiry against issuance of transfer to newly appointed APS dealer. As per instruction of the Principal Secretary, Food and Supplies Department, dated 20th May 2025, kindly take note. You are directed. Who is directed? Subdivision Controller Tomlu. He is not my licensing authority. So, dictation of the Principal Secretary, direction has been given by the District Controller to an authority who is not my licensing authority. My licensing authority became satisfied. I have shown my lord from the order impugned. Once again, I am reading page 44. Whereas, third paragraph, as if the report submitted by the licensing authority on so and so. Who is my licensing authority, my lord? I have shown to your lordship.
SCFS contact.
My lord, regarding the above mentioned allegation, found unsatisfactory. But can it be done? A person can judge his own cause. He has submitted a report. Now, subsequently, he says, no, my report is not satisfactory. There should be a further inquiry. I have never crossed this type of sentence. An official says, my report is not satisfactory. There is a need of further inquiry. He is my licensing authority. I think this is a fit case. The first day it should be quashed and set aside. Paragraph 26 of the judgment I have just raised before your lordship. That is the vital paragraph.
May I read, my lord?
Paragraph 26.
Yes.
The contention was raised before the High Court that the circular dated such and such has been issued by an authority having no competence, thus cannot be enforced. It is the settled position of that the authority which has been conferred with the competence under the statute alone can pass the order. No other person, even a superior authority, can interfere with the function of the statutory authority. In a democratic setup like ours, person occupying a key position are not supposed to mortgage their discretion, violation of decision-making authority, and be prepared to give way or to carry out commands having no sanctity of in law. Thus, if the decision is taken by the statutory authority at the behest or on suggestion of a person who has no statutory role to play, the same would be patently illegal. This is the penalty.
He alone can do it. As per dictation, he cannot. And I have never crossed any case. I have few cases where so far this subject is concerned. That a person concerned, responsible person, licensing authority is saying, my report is not satisfactory. He should be punished. Proceeding should be initiated against him. This is the fifth case. At the first day, lordship shall quash and set aside, and proceeding should be initiated against the person concerned. Right, these are my submissions.
Yes.
Good judgment.
No, my lord, before I open the case, my case, my lord, pursuant to the order of termination at 8th of August 2025, there is a corrigendum, only to the extent that the word termination has been substituted by the word revocation.
My lord, we have not received, but my
Only but the termination may be read as my lord, the revocation. Lordship may have a look to the last but one paragraph. We have got it also, my lord, only this morning. So we couldn't take out the printout also. My lord, the lordship,
Here revoked.
yes, my lord, it is revoked. My lordship takes the penultimate paragraph. Revocation, well, the termination and revocation, my lord, there's something which is revoked. Termination means something is cancelled, it equal to, but revocation means it goes to the root of the matter as if nothing was given. Now, my lord, so, my lord, I'll bring it on record.
Is there any provision for revocation of license in the control order?
My lord, I'll come to that, my lord. I'll
Yes.
come to that.
There is no such termination maybe. No such
my lord.
revocation order is there.
My lord, lordship kindly permits me
Yes.
to, I shall show to lordship, my lord. Lordship, my lord, kindly comes to the page 42.
Yes.
I just reply one by one, my lord. Lordship kindly comes to page 42 P6. This is from the District Controller Food and Supply Purva Medinipur to the Subdivisional Controller Food and Supplies Department, Tomluk. This is 20th of May 2025.
Yes.
May I read for your lordship once again? This has been placed by Mr. Saharai, but I need to place it once again. Subject: re-inquiry against the issuance of APS license to newly appointed APS dealer Mrs. Oshima Mondol in Dokhin Murabania under Bamunia Gram Panchayat in Deshopran Block, Kontai. Now, my lord, the text is as per instruction of the Principal Secretary. My lord, I just pause here. Instruction of this Principal Secretary, Food and Supplies Department, dated 20th of May 2025, you are directed to conduct a discrete inquiry. This is very important. But instruction, discrete inquiry into the above and said subject within 25th of May, positively, and submit a report to the undersigned within 27th May 2025 for onward submission to the department by 31st May 2025. Sri Shubhadeep Roy, Chief Inspector Food and Supply attached to the department, will assist you in conducting the inquiry. Now, my lord, this document has been relied on heavily to persuade your lordship invoking the doctrine of dictation. But in my humble submission, this doctrine of dictation has no application in this case. It is
Yes.
doctrine of dictation has no application because this is an instruction for an impartial inquiry, discrete inquiry. Why I call it impartial? Because the impugned order of revocation, I would say now, my lord, has been issued by the Subdivisional Controller Food and Supply Kontai, and the re-inquiry has been directed to be conducted by the Subdivisional Food and Control SCA Tomluk,
Yes.
a different authority, because that will, your lordship will find that instruction for a discrete inquiry and for submission of a report. So this letter cannot be construed to be a dictation from the higher authority, as has been alleged. So, my lord, here, if your lordship, my lord, I just take your lordship to the page 44. Page 44. The penultimate paragraph once again. Why I am showing this? This is the part of impugned order. The APS dealership of Washimamoto is hereby terminated. It may be read as revoked on the grounds of flawed selection process based on erroneous inquiry report. Now, my lord, this flawed selection process based on these are two really grounds on which the revocation order has been passed. Fraud selection process, it is not the cancellation of or revocation of the license. This is revocation of the flawed selection process. So it's the selection, if the selection is bad, and if there is error in holding inquiry, and if if the selection process is based on erroneous inquiry report, so there is no difficulty in revoking the what is called this license. Because of the simple reason, any inadvertent error or mistake does not confer any right. This is the well-known principle of law. I need not tell your lordship about it. Your lordship knows this. Now, my lord, here he is claiming right to continue with the license issued to her inadvertently based on flawed selection process and erroneous inquiry report. So the error has been corrected now. So where is the wrong? Kindly, my lord, visualize from my side what I look at it. My lord, kindly try to understand, my lord. Flawed selection process is the basis and erroneous inquiry report is the basis. So there is that, therefore it is revocation. And the result of that is the license of fraud selection process or erroneous inquiry does not confer any right to the licensee to carry on his business, and that is why this revocation. Now, my lord, now, my lord, lordship, this is, my lord, the gist of the matter in my humble submission. Lordship kindly sees. My lord, I'm sorry, my lord, if my lord, the instruction of the principal secretary for a discrete impartial inquiry by another food SCFS Tomluk, not the licensing authority here. The purpose is that I repeat, my lord, because of the flawed selection process and erroneous inquiry report. So there is nothing wrong in it. So, lordship, kindly, I just place, my lord, this and my lord,
is there any provision in the control order?
No.
That after issuance of license, if it appears that an inquiry report and all the reports submitted during the course of during the course of appointment appears to be some faulty one or flawless inquiry is there, is the secretary has the authority?
my lord, the
Statutory authority is the secretary has the authority to take his own accord.
24 control order. 24 control order that.
Is there any provision?
My lord, lordship,
Not
my lord,
such much. It cannot be.
Ah.
The moment I became the licensee, all procedures should have to be followed. That's the judgment delivered by your lordship in another matter. The moment I become licensee.
that is the different aspect altogether. Let me finish my submission.
Yes.
Now, my lord, here, my lord, I'll just show to your lordship, my lord. Here, my lord, what I find, my lord, that the application of principle of naturality has also no application, because there is an inadvertent error which has been corrected, rectified. So the principle of naturality is not a straitjacket formula, as has been held by the Supreme Court in a number of judgments.
I want to know how the principal secretary has come to opinion that the inquiry report which was submitted during the course of appointment was erroneous. How he satisfied without taking hearing, without taking any order?
My lord, I just tell you, lordship, my lord.
Is there anything I want to know? Is there anything, any document?
My lord,
with you, Vanessa?
I think, my lord,
Only on the
Is there
basis of the
anything?
comment.
Or whether there is any report of the district DDPS that the inquiry report submitted by the SCFS Contai is not satisfactory.
Now, my lord, here, my lord, it is there in the, my lord, it is there, my lord, I just place, my lord, page 43 once, my lord,
Yes,
first, second, third, fourth. First, second, third. Whereas the report, I omit the first two paragraphs. Whereas the report submitted by the licensing authority dated 11th of April 2025 regarding the above mentioned allegation found unsatisfactory.
yes. It is the order of the Contai itself, Contai, SCFS Contai.
Lordship.
Unsatisfactory. But if you read the page 42, that is the order of the letter of the district controller to the SCFS Tamluk,
Yes.
it is said that as by instruction of the principal secretary, he has not said anything regarding his dissatisfaction.
My lord, my lord, I got
Do
this.
you have any document or like that?
No, not now. My lord, I didn't get the opportunity, my lord. It was the leave matter, my lord.
Yes.
I got it late evening yesterday. I couldn't talk to my clients even. So I have come in the morning as a first matter here. So, my lord, I didn't get that instruction, my lord. Now, my lord, here, my lord, lordship will find, here, my lord, what I find, my lord, just on the basis of the records, without any instruction from the authority, accepting that revocation has taken place instead of termination. Accepting that, I haven't got any instruction.
Okay.
Now, my lord, because, my lord, what I find, my lord, the dictation, my lord, this is not a dictation. But when it came to light, or it was revealed that there was a flawed selection process, the principal secretary instructed that there should be a discrete impartial inquiry by another SCFS. That is Tamluk. And this, on the basis of the report, my lord, the
Most probably disciplinary proceeding was also started
my lord,
against the
some of the officers are facing possibly departmental inquiry.
possibly.
Possibly, I don't know. I don't know. I'll take instructions, but this should be. Should be because, my lord,
Should be against the principal secretary.
ঠিক আছে ভাই একটু wait করো না. Have your breath. Have your breath.
আমরা দেখে বোঝা যাচ্ছে কি হয়েছে কে কমপ্লেনেন্ট আর কে পিটিশন
Now, or I get diverted if running commentaries are there. I get diverted. I can't concentrate on my
You will
breath.
you just stop first.
Mr. Sahil will have his breath. He will have his turn.
Yes. Mr.
Now-
Doctor, this is the order of termination, and you said that the term that is at last page 44
Yes.
thereby revoked.
Yes.
But whether order of revocation or termination?
This
The
should be it is a revocation.
Now, heading. What is the whether there is change in the heading? Page.
In the by a corrigendum,
Yes, correct.
the word my lord, termination has been substituted by revocation.
Whether I want to know whether order of termination is there or order of revocation is in the corrigendum.
The corrigendum
Order of revocation.
order of revocation.
Revocation. First page. First page.
First line, first page.
Yes, order of revocation.
Yes, Lordship.
And the the penultimate paragraph also.
Yes.
I'll hand up my lord, the hard copy, my lord, I'll hand over. But or my lord, your lordship directs, I can. This is the corrigendum. Now, what I was submitting, my lord, that this revocation is the result of a discrete inquiry made by another SCFS.
Yes.
Because of the flawed selection process and erroneous inquiry report submitted by the inquiry officials, that is why this revocation order has come. Now, I was trying to place before lordship, paragraph page 43, the third paragraph, whereas a report submitted by the licensing authority dated 11th of April 25 regarding the above mentioned allegation found unsatisfactory. This GCFS Purva Medinipur entrusted SCFS Tamluk to cause a thorough inquiry in this regard. Whereas SCFS Tamluk conducted an inquiry regarding this subject matter, and in his report he has mentioned in detail some serious discrepancies between the physical go down and the inquiry report submitted by the inquiry officials during vacancy inquiry done in the month of August 2023. The major discrepancies are as 1, 2, 3, 4. But this has been placed. The inquiry report as submitted by the inquiry officers during vacancy inquiry done in the month of August 23 does not mention the fact that the proposed go down is a residential house with major issue of access to first floor through the sale area, which makes the go down not suitable. During physical inquiry and measurements on 30th of May 2025, it was found that lots you can see the discrepancy that the premises offered by Srimati Shima Mondol as proposed SCFS go down, PS go down, has two proper rooms, 25 feet into 11 feet with approximately 6.75 square feet, which can be treated as go down. There is total 283 square feet of area in the veranda, which cannot be considered for storage or sale area because of presence of a staircase across first floor such and such. There is one proper room with 11.5 feet into 11 feet, that is 126.5 square feet, can only be considered as sale area. The room 3 mentioned in the inquiry report was physically found to be dimension 24 feet 10 inches into 6 feet 9 inches, that is 1 is not fit for storage of food grains and should not have been considered as go down space during inspection. Thus, the area of the proposed shop becomes approximately 266.75 square feet and cell counter becomes 126.5 square feet, which does not conform to go down specification as laid down in the Gazette notification. Then next page 44. The inquiry report at the 30th of May 25 transpires that the approved candidate, Oshima Mondal shop come go down, was not up to the mark of eligibility as laid down in the vacancy notification number so and so. Pausing here for a moment, not up to the mark of eligibility as laid down. Lordship kindly notes this. This is also one of the reasons. So this is the Malad fraud selection process. The reason is here. Why it is fraud selection? Because the specifications, the go down, the veranda, the complainant Tahomina Khatun's Bibu's shop is also found inappropriate in respect of the said notification as the proposed FPS shop come go down is a complete residential house with people dwelling in that place and not suitable for PDS. This is another. Now and therefore the FPS dealership Washington Motor is thereby terminated on the grounds to be read as revoked on the grounds of fraud selection process based on erroneous inquiry. And the vacancy will be notified. These are all stock allegations. Now, Malad, I just conclude my submissions, Malad. Huh? Yes, vacancy will be re-notified in due course. It has not been done. And for smooth running of public distribution system, the terminated, that is revoked FPS is being tagged with the nearest FPS dealer, Sumita Jana, issued in the interest of uninterrupted PDS. This is, Malad.
Total selection procedure go down is the main criteria.
Yes. Well, the eligibility criteria as laid down in the vacancy was not fulfilled. And the selection process, admittedly, selection process was flawed. I am rectifying my mistake. I am rectifying my error, which I can do. If I commit a mistake inadvertently, it is a bona fide one. I can rectify it. And this mistake or inadvertent error cannot or does not confer any right on the licensee to carry on her business. And Malad,
That's why the other officer was interested in it is
Malad, the district inquiry was conducted by another SCFS Tomluk because the previous one made some mistakes and there was Malad, there was flaw in the selection process and erroneous inquiry. These two things, Malad, nothing more I can say right now. Now, Malad, because of this revocation and based on because I can correct and this and Lordship knows, Malad, there is no Malad, while considering a judgment, Malad, I just Malad, Lordship kindly consider Malad order 1. Order 1, Rule 9. Order 1, Rule 9.
Yes.
Your Lordship, 9 and 10. Your Lordship knows this, I know. Order 1 का बताया
ये तो section.
order 1 था ना
এই যে order,
order
এই
1.
যে order.
Yes. Lordship kindly sees my order 1, Rule 9. Misjoined and non-joined, Lordship got. Your Lordship knows it, but then I must place it because this has been considered in a judgment of the Supreme Court. I just take your Lordship there. No suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may, in every suit, deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. Then 10.1. Suit in name of wrong plaintiff. Where a suit has been instituted in the name of the wrong person as plaintiff, or where it is doubtful whether it has been instituted in the name of the right plaintiff, the court may, at any stage of the suit, if satisfied that the suit has been instituted through a bona fide mistake. Lordship, kindly, this is in italics. Bona fide, it is in italics. There is a purpose for it. Bona fide mistake, and that it is necessary for the determination of the real matter in dispute, so to do, order any such person to be substituted or added as plaintiff upon such terms as the court thinks fit. So, my lord, this is the CPC, and this has been relied on. Judgment well, I just rely on page 715. Yes.
2014 volume.
Just one judgment, my lord. I just
2014.
My lord.
2014 volume 15. If I may start with the head notes, then I'll relevant paragraph. Just head notes at the top. A. Section 79, Order 1, Rule 910. Suit against the state. Relief sought to be enforced against the state, but is not implemented as a party. Held. Suit not maintainable. Furthermore, decree within brackets erroneously passed in such suit would not bind the state even if such decree has attained finality. My lord, I submit in, I'll place the paragraphs. My lord, I erroneously issued a license. I'm revoking it.
No, that is the separate, completely separate ideas and nomenclatures. This is the parties to the suit.
Yes.
Develop parties to the suit. When a party erroneously not impleted, what is the effect if the suit is finally declared?
Lordship, I'm grateful. Yes.
Only enter.
Yes. Lordship kindly says, next, my lord, B. Order 1 Rule 910, necessary party, non-implement, not maintainability of suit. Decree erroneously passed in such suit would not bind such party even if decree attains finality. Lordship, my lord, then my lord, Lordship kindly comes to my lord, then paragraph, my lord, I just. চুপ কর না একটু কথা বলতে দেন
14 to 16
ইররিলেভেন্ট জাজমেন্ট দেখাচ্ছেন তাই করছি আবার কি আছে
irrelevant judgment কিছু নেই try to understand the law
কোন পয়সা স্পোর্টটাই
Yes, proceed.
Lordship kindly takes my lord the paragraph 12. Lordship, I start from paragraph 14 to 16.
Yes.
Thus, we are of the considered opinion that the suit was wrongly decreed. It is also intriguing to note from the said judgment that the defendant appeared and filed a written statement and admitted the claim of the plaintiff therein. Therefore, the judgment is not worth putting any reliance on. The finding of fact has been recorded therein that Karam Singh DW1 admitted during cross-examination that the Punjab government gave. So I just omitted. Next paragraph. So here is a suit which was decreed on the admission of the defendant against whom no relief was prayed for, and without implementing the necessary party. We are equally amazed to find that the state of Punjab implemented the judgment. It leaves such much
to be desired. 15. Thus, in view of the fact that the judgment and decree in the case of Charanjit Lal seems to be collusive, and in a suit which itself was not maintainable, we are unable to accept the submission advanced by Sri Garg, the learned counsel for the appellant. 16. More so, it is also settled legal proposition that Article 14 does not envisages the negative equality. In case a wrong benefit has been conferred upon someone inadvertently or otherwise, it may not be a ground to grant similar relief to others. The court was considering the question of negative equality under Article 14. That is, now this I repeat, in a case of wrong benefit has been conferred upon someone inadvertently or otherwise, it may not be a ground to grant similar relief to others. This court in Basavaraj versus Land Acquisition Officer so, then paragraph 8 is quoted. It is settled legal point the Article 14 of the Constitution is not meant to perpetrate illegality or fraud, even by extending the wrong decisions made in other cases. The said provision does not envisage negative equality but has only a positive aspect. Thus, if some other similarly situated persons have been granted some relief benefit inadvertently or by mistake, such an order does not confer any legal right on others to get the same relief as well. If a wrong is committed in an earlier case, it cannot be perpetuated. Equally is a right which cannot be claimed in illegality and therefore cannot be enforced by a citizen or court in a negative manner. Well, this is very vital for my case. If an illegality and irregularity has been committed in favor of an individual or a group of individuals or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of the higher court or superior court for repeating or multiplying the same irregularity or illegality or for passing a similarly wrong order. A wrong order decision in favor of any person party does not entitle any other party to claim benefit on the basis of wrong decision. Even otherwise, Article 14 cannot be stretched too far, for otherwise it would make functioning of administration impossible. The ratio of the judgment is that wrong decision or wrong order or the irregularity or illegality cannot be perpetuated and it does not confer any right also. This is possibly in my read, this is the ratio of the judgment. And this is taking a clue from the CPC Order 1, Rule 9 and 10, where if there is inadvertent error between the parties, I understand what is passing to Lordship's mind. But here, Lordship kindly the Supreme Court has considered this to come to this decision. Why there is a purpose behind it? Because it has been, Lordship kindly sees here, the decree erroneously passed would not bind the state. So, this, yes, admittedly, I have committed an error. Admittedly, there was wrong selection process, and the result and the wrong inquiry process, and the result is the license given to the petitioner. Now that has been revoked. I can, if I do something wrong, I can rectify it. Now, my lord, since this is a case of revocation, my lord, the principle of natural justice has no application. It has no application in the present case, in the factual matrix of the present case. Doctrine of revocation doesn't apply. But this was simply instruction. The principal secretary did not say you revoke the license or terminate the license. Did not say you, because the selection process is erroneous and found to be not in order. So make a discrete inquiry by another SCFS, and that has been done, and that has been relied on for revocation of this license. These are my submissions, my lord.
Yes.
Nothing more, my lord.
The duty of the advocate is to defend his client everywhere, but in some cases, possibly, my lord, law should be.
I believe in efforts, not in result.
Effort should be in the four corner of law. Well, first submission has been advised by my learned senior friend, revocation. I have never seen this term in any books so far the public distribution is concerned. It may strengthen my case once put ahead. Now you are using a term which is not permissible under the control order. There is no such provision, revocation of license. Termination, suspension, penalty, I could have understand. Now, the second point which has been argued before Lordship, my lord, that the subdivisional controller himself has came to a conclusion his report is not satisfactory. My lord, kindly come to page 42. Page 42 does not say either the principal secretary or the director or the district controller found the report submitted by the contai is erroneous. There is no whisper. Report submitted by the subdivisional controller has never been nullified by any higher authority even. Kindly take note of my lord, page 42.
May I take your lordship kindly?
Yes.
I have made I don't have any right to reply to a reply.
Well, kindly take note of page 42. As per instruction of the Principal Secretary, Food and Supplies Department, dated so and so, you are directed to conduct a discrete inquiry into the said subject within so and submit a report. It does not say the report submitted on 11th of April 2025 by the contai is not acceptable either by the director or by the Principal Secretary or by the district controller. That report, kindly see the next page, the date. It is dated, second paragraph, third paragraph, 11th April. After that, this instruction has been given. No whisper that the report of the contai has not been accepted, either by the Principal Secretary or by the director or by the district controller. Now, another point has been urged before your lordship. Fraud, the moment it will be detected, it can be rectified. But kindly take note of the control order. Just for a moment, my lord, page 19. The books is the new book under 2024 control order.
Page
My lord, 19, first paragraph, subparagraph 6. Selection process, it starts from page, my lord, 17, 13, clause 13, 6. May I read, my lord? Page, my lord, 19, top.
yes.
On receipt of the recommendation from the district level fair price shop selection committee, kindly take note of. The director shall consider the recommendation and also from his own opinion regarding eligibility and suitability of the recommended candidate by the district level fair price shop selection committee, and after being fully satisfied with eligibility and suitability, accord approval for grant of fair price shop license to the most suitable candidate for filling up the vacancy. On receipt of the report under the so-and-so, as the case may be, the director may grant approval for engagement of the most so-and-so. The subdivisional controller sitting as appellate authority, so far this opinion is concerned. Ultimate approval has been granted by the director on satisfaction. He is now cancelling the approval of the director also. The appellate authority of the director is the Principal Secretary. He has never said, your report I am not accepting. Director is never saying, district controller is never saying. At least from the imprimatur, it appears he himself came to a conclusion his report is not satisfactory, not by any other authority. I fail to understand, my lord, what judgment has been placed before lordship. It says, as I understood, my lord, a person who is not a party in a proceedings, if any decree is passed, that is not binding upon him. And another analogy has been considered by the Supreme Court, that wrong cannot be perpetuated. If a person gets some relief by way of a wrong decision, another person cannot come. But I fail to understand why this judgment has been placed before lordship. But this is a fit case. At the first day, it should be quashed and set aside with a direction upon the higher authority to initiate proceedings against the contact subdivisional controller and also the subdivisional controller Tumbu. How he can nullify the report of his colleague sitting in the same chair? Well, these are my submissions.
Yes. Please take down.
গুছিয়ে রাখছো পড়া তো উচিত মহামানব কমপ্লেন করলে মহামানব তো দেখবেই
Petitioner took part in a selection process in terms of vacancy notification issued by Subdivisional Controller Food and Supply Contai for filling a vacancy of MR dealership. After due formalities, the petitioner became most suitable candidate. An offer letter was issued in her favor by the concerned subdivisional controller, by the Food and Supply Department, Government of West Bengal, on 5th of December 2024. Fair price of fair price of license was issued in favor of the petitioner on 7th of June, 7th of January 2025, which is valid till 31st of December 2025. Under the strength of such license, the petitioner is catering ration articles to the beneficiaries under his PDS, under her PDS code. The petitioner on 20th of May 2025 said 20th of May 2025 suddenly received an intimation from the District Controller Food and Supply Purva Medipur in respect of a letter dated letter to Subdivisional Controller Food and Supply Kamluk Purva Medipur to conduct a discrete inquiry as per inquiry at the FPS of the petitioner as per instruction of Principal Secretary. The letter dated 20th May 2025 is set out herein under for better appreciation of the facts. 20th May 2025 is set out here under for better appreciation of the fact. Set out for page 42. Dated ডেটটা দিয়ে দেব, ঠিক আছে? Thereafter, on 8th of August 2025, the petitioner received an order of termination of FPS from her licensing authority, that is Subdivision Controller Food and Supply Contai. The order of termination is set out here under for better appreciation of facts. Page 43, 42. Learned Counsel, Mr. Devabrata Sahara. Next part. Learned Senior Counsel submits that the order of termination issued by the Subdivisional Controller Contai is erroneous and under dictation of the higher authority. He submits that the present petitioner, being the licensee, have never given an opportunity of hearing or any scope to demonstrate in the inquiry proceeding. Demonstrate his case in her case in the inquiry proceeding. He further submits that the entire case relates to the instruction of Principal Secretary Food and Supply, who initially directed the SCFS Contai to conduct an inquiry. The SCFS Contai has conducted inquiry on 11th of and submitted a report on 11th of April 2025. On perusal of his report, the principal secretary dictated district controller to again re-enquire the FPS of the petitioner through another subdivisional controller, that is SCFS Kamru. He submits that the entire procedure adopted by the respondent authority he submits that entire procedure adopted by the respondent authority is unreasonable and malapplied. Thus, it requires to be set aside. He further submits that the principal secretary that the impugned order of termination contained a complaint of one Tahmina Khatun. Such complaint was never handed over to the petitioner, or the petitioner has not given any opportunity of hearing. Thereby, valuable right of the petitioner regarding the principle of natural justice has been violated in this case. He for setting aside the impugned order of termination. Next, Mr. Dotto, Shapon Dotto, learned senior counsel, AGP, submits that a complaint was made to the principal secretary, who conducted a discrete inquiry at the FPS of the petitioner, wherefrom it appears that at the time of appointment of the petitioner, the selection process has been flawed, FLAWAD, on the basis of erroneous inquiry report. The concerned department, under the instruction of the principal secretary, has only rectified the mistake conducted by the concerned officials during the appointment process. He further submits that there is no scope for dictation by the upper authority, the principal secretary has only instructed to conduct a discrete inquiry, full stop. He submits that the principal secretary has all authority to rectify the mistakes of the department at any time. He further pointed out some relevant portions of the impugned order of termination, wherein the inquiry report which was submitted by the inquiry officer during vacancy inquiry appears to be erroneous on physical inquiry by the SCFS Tombu. Mr. Dotto further submits that any person cannot claim negative equity. The order of the license was granted granted on the basis of erroneous inquiry report, negative equity, full stop. The negative equity, full stop. The license license in favor of the petitioner was granted on the basis of erroneous inquiry report. Thus, the department has every opportunity to rectify the mistake. Thereby, the license of the petitioner was terminated. Next, it is the further contention of Mr. Dotto that there are a corrigendum of the impugned order dated 8th of August 2025, which disclosed that instead of order of termination, order of termination within inverted comma. Order of termination. It was corrected as order of revocation. In the last para of the impugned memo, impugned order, the FPS dealership of the petitioner was revoked, not terminated. Revoked within inverted comma. In support of their contention, in support of their respective contentions, Mr. Saharai placed some judgment of this court passed in Khurshid Alam Khan versus State of West Bengal, wherein this court has observed that once a license was granted in favor of an individual, the license can only be terminated in terms of the provision laid down in the impugned control order, the relevant control order, not by other way, not by any other way. Mr. Sahara also placed a decision of Honorable Division Bench of this court dealing with the same issues, dealing with the relevant issues passed in State of West Bengal and other versus All Bengal Fair Price Shop Dealers Welfare Association and another within bracket MAT 2354 of 2024 bracket close, wherein the Honorable Division Bench, under the assurance of Learned Advocate General, has passed an order that the state shall always duly comply with the principle of natural justice at the time of imposing penalty upon any FPS dealer. Next paragraph. Mr. Sahara has also placed reliance upon decision of Honorable Apex Court passed in Joint Action Committee of Airline Pilots Association of India, versus Director General of Civil Aviation, reported in within bracket 2011, 5 SCC 435, paragraph 26. Set of code. Learned AGP Mr. Datto has also placed reliance upon the decision of Honorable Supreme Court reported in Chaman Lal versus State of Punjab and others, reported in within bracket 2014, 15 SCC 715. Paragraph 16. Set of code. Having heard the learned counsel for the parties, also considering the proposition of law as enunciated by this court as well as the Honorable Division Bench and Honorable Supreme Court, it appears to me that the legal proposition of state action at the time of revocation of revocation at the time of termination of license has time and again considered this court as well as the Honorable Division Bench. In all aspects and in all the matters, this court has directed time and again that the principle of natural justice should be followed before termination of any license issued by the state in favor of any individual. Full stop. Mr. Dotto has placed reliance upon the decision of Honorable Apex Court in Chamanlal, wherein the Honorable Apex Court in deciding the in deciding relevant parties to a suit under order 1 of CPC has categorically ruled that when a necessary party was not impleaded in a suit, comma, if the suit is decreed and the decree attained finality, then also for non-impleading the necessary parties to the suit, such necessary party is not binding upon the decree. Is not such necessary part such no cut off such final decree is not binding upon the necessary party who was not impleaded in the suit. In deciding such issue, the Honorable Apex Court within bracket Chamanlal bracket close has discussed about the legal proposition of negative equity as enumerated under Article 14 of the Constitution. The Honorable Apex Court in deciding Basarwaj BASAWARAG versus Land Acquisition Officer. Honorable Apex Court following Basawaraj BASAWARAG versus Land Acquisition Officer within bracket 2013-14 SCC 81 has observed that if on the basis of fraud and illegality one wrong decision was obtained, no one can place reliance upon such decision or claim negative equity. Full stop. Next paragraph. In deciding the facts of this case, in deciding the present matter, it appears that one unsuccessful candidate, namely Tahmina Khatun, has lodged a complaint. Tahmina Khatun has lodged a complaint to the Honorable Chief Minister against license granted in favor of the petitioner. The impugned order itself disclosed the fact that the allegation is only non-possession of some legal document in respect of proposed FPS go down of the petitioner. On such complaint, the principal secretary has directed the district controller Purba Manipur to conduct an inquiry. Full stop. The initially SCFS Contai has conducted inquiry and submitted a report. Principal secretary again directed district controller that a re-inquiry is required to be made in respect of FPS of the petitioner through SCFS Tamluk Purva Manipur. Full stop. After thorough dissection of the entire conduct of the state action impugned herein, it appears that on the basis of an complaint of an unsuccessful candidate, the principal secretary acted to conduct an inquiry. Initially, licensing officer concerned, that is SCFS Contai, has conducted an inquiry, but it appears that though such inquiry report was placed with the authority, but no one has recorded dissatisfaction about such inquiry report, and again the principal secretary directed district controller to conduct inquiry through SCFS Tamluk. Moreover, the impugned order has disclosed some erroneous finding of inquiry report submitted by the inquiry officers during vacancy inquiry, which is purely regarding the area of FPS of the present petitioner. The SCFS Tamluk is of opinion that some area is some room of FPS of the petitioner is not fit for storage of food articles. Full stop. It further appears that there is no such hint of illegal possession of proposed FPS godown by the petitioner on the basis of proper document. On the basis of non-possession of legal documentation. Non-possession of legal documentation. Moreover, the authority concerned has suddenly, by an order of corriendum, has changed the nomenclature of the impugned order to be order of revocation instead of order of termination. Full stop. Next, push up. The order of revocation of FPS license is unknown to the control order. Full stop. I make it clear that after considering the entire aspect, it appears to me that the impugned order passed by the concerned subdivisional concerned licensing authority, that is subdivisional controller Food and Supply Contai, is erroneous on the above mentioned grounds. Number one, the petitioner was never given any opportunity to see the complaint of Tahmina Khatun, an unsuccessful candidate. Full stop. Petitioner never given any opportunity of hearing before order of termination. stroke order of revocation. Full stop. The order of termination stroke order of next project see korbe order of revocation or sorry order of termination or order of revocation is not according to the control order. Full stop. The district controller food and supply Purva Medinipur has not ever recorded his dissatisfaction over the inquiry report conducted by the SCFS Contai. Moreover, the district controller, who is the district, moreover, the director DDPS, who is the authority to finally accord permission for selection of a candidate in respect of FPS, has not placed any finding regarding his earlier decision of granting license in favor of the petition. Full stop. Next paragraph. I make it clear that when a license was granted in favor of any individual after complying with all formalities according to the control order, the authority concerned can only revoke, stroke, terminate the license, only terminate the license in accordance with the control order. Full stop. I make it clear that the provision of law has been declared in a very critical way in respect of the state action. In respect of state action. Full stop. The state who has source of power under a statute can act only on the basis of the statute only, not in another way. On the other hand, an individual who is a citizen of India can act any action according to the law, but the state authority are bound by the provision of law by which they are only empowered. Under the above observation, it appears to me that the impugned order passed by the impugned order of termination of FPS license dated 8th of August 2025, and thereby the corriendum, that is order of revocation issued by the concerned authority, appears to me.
Dated 14th
August 2020.
14th August.
Order of revocation dated 14th of August 2025, issued by the concerned authority. 8th of August 2025, 14th of corriendum dated 14th of August 2025, appears to me illegal and erroneous, and I find justification to stay the operation of the said order of termination stroke order of revocation. Full stop. The stay for a period of 10 weeks from date. 10 weeks from date. The authority concerned is directed to allow the petitioner to run the FPS according to the control order.
They will
within a period of
7 days.
within a period of 2 weeks. Full stop.
It is only about
However-
paperwork. It can be about 7 days. Only paperwork.
Okay, within 10 days. Within 10 days. Full stop.
Okay.
However, it appears that the justification to issue such order of termination strokes order of revocation by the state authority may be properly demonstrated before this court by filing an affidavit in opposition. Accordingly, the state authority is directed, state respondents are directed to file an affidavit in opposition against the writ petition within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list, particularly.
Or instead of 10 weeks, it will be a puja vacation. It may be 12 weeks.
10 weeks.
No. Or it will be ended on 28th during the puja vacation. It may be 12 or 10 week, 11 week or 12 week.
10 is not completing puja.
No,
28.
28.
4, 8, 8,
Make it
4,
12 weeks.
8. Okay, 12 weeks.
I'm good. Much.
My lord, the granted
Affidavit
along with an interim order to granting stay for 12 weeks, 10 weeks to the impugned order of revocation.
12 weeks.
12. Next.
Yes. ওইটা দেবেন কন্ট্রোল অর্ডার may I take back the control order, new control order এখানে একটা রাখবেন
ওই জন্য টেকটা দেখে
I've get much.
It's a matter item number 8.
And for the statement.
Lordship, I appear for the petitioner. Lordship, we were supposed to file the exception to the report filed by the state.
Okay, please take down. Exception to the report in the form of affidavit filed on behalf of the state respondent.
By the
State
petitioner, my
economic-
lord.
Taken on record. Okay. Let the matter appear in the list on 26th of August under the same heading for hearing. Next.
Item number 9.
Lord, I'm appealing for the state order. I have the instruction, my lord. I haven't filed the order because of the affirmation is required by the officer, my lord.
Affidavit ready?
Almost ready, my lord. Just the signature, the affirmation is required.
Look, I fixed these matters on 26th of August. All the matters, there are at least 20 to 30 matters are there of similar nature, similar principle is there to be decided. So you get ready. Can you file it within the next week?
My lord,
25.
I'll file by
Lordship kindly keeps the matter on 26th itself, my lord. In the meantime, he'll serve me an advance copy. We can proceed.
I can file it by 26th.
An accommodation is sought for on behalf of the state respondent to file a report, to file the report. Accordingly, let the matter appear in the list on 26th of August 2025 under the same heading. So parties are at liberty to exchange their affidavit in the meantime.
No.
Next.
Grateful, my lord.
Item number 10.
Lordship, I appear for the petitioner, my lord. This is steam notification matter, my lord, 2024 order. The state was supposed to
The
file
matter
the
appear
report.
in the list on 26th of August 2025.
Lord, report has not been filed by the state.
Understand. 26th of August 2025. Parties are at liberty to exchange their affidavit in the meantime.
Lordship kindly records the state was not present, my lord.
Of course,
When
state
that
is
matter.
present.
Oh, the state
Report
is
is
there.
there.
Yes, my lord.
Give me the report.
The matter to be disposed of, my lord, because we are not a single card from detecting for the petitioner's account, my lord.
Is it?
No, that can be heard on the 26th, my lord.
No, my lord.
Yes.
Why 26?
That will be reflected, my lord, in the report.
Lord, then kindly keeps it tomorrow, my lord.
Nothing.
Mr. Huda is not there.
Yes, my lord. Not a single card from detects from the petitioners.
Then how you file this writ?
Lordship, we've got to know this now, my lord. We were not even
1,500
served with
card
the
was
copy of the
detected
report,
from
my
the
lord. We have to
lodgers
go
on
through the
previous
report,
occasion,
my
my
lord.
lord.
Copy to them.
Yes, I'm sorry.
To serve a copy to them.
Last
Let the
occasion I
matter
also
appear
take.
tomorrow.
Lords.
He is not instructed.
Lordship.
Report in the form of affidavit filed on behalf of the respondent number 1 to 4 be taken on record. Copy served.
আমি সেদিনও বলেছি।
Copy served. Let the matter appear tomorrow for further hearing under the same heading. Next.
Grateful, my lord. Oh, awesome.
Nice to see you.
Lordship, I appear for the petitioner, my lord. The petitioner has expired.
Oh,
Expired.
Yes, but we do not have the death certificate as of now, but we have got to know that he is expired.
but ওর পরে তো তোমাকে দেখতে হবে না কি করতে হবে
Hmm.
তোমাকে সাবস্টিটিউশন করতে হবে
Yes, yes, we have not been able to build contact with the family. There's such
फिर जो bereavement होगा
Lordship, kindly.
Okay.
and we have submitted our
Here report is
yes
there.
report.
Yes, yes.
Learned counsel
Fact, the
appearing
exception
on
is
behalf
also
of the
ready, but
petitioner
because of
submits
ঠিক
that
আছে,
the
ঠিক
petitioner has expired during the pendency of the instant date petition. On consideration of such submission, the petitioner is directed to take appropriate steps. On consideration of such submission, petitioner is directed to take appropriate steps. Let the matter go out of the list. Parties are at liberty to mention. Next.
Lordship, I am for the petitioner, my lord. The state was supposed to file the report, my lord.
Are you there? Let the matter appear in the list on 26th of August 2025 under the same heading. Parties are directed to exchange their affidavit in the meantime. Next.
Lordship, I am for the petitioner, my lord. The report has been submitted, my lord. The exception is ready, my lord. However, it has not been affirmed, my lord. We'll get it done by this week, my lord.
Let the matter be appear in the list on 26th of August 2025 under the same heading. Petitioner is leave to use the exception in the meantime.
Our report has already been filed.
Yes.
Yes.
Next. Not today. Next.
Sir, Lordship, in item number 16, I am for the petition. Lordship, we were supposed to file an exception to the report filed by the state, my lord. Just now serving, sir.
Exception to the report in the form of affidavit filed on behalf of the state respondents be taken on record. Full stop. Let the matter appear in the list on 26th of August 2025 under the same heading. 26. All the matter in
All the matter, your lordship.
all the matter.
Lordship, this matter, 26 will not be convenient for us, my lord, because we have many matters fixed at that day, and this is a not
Hearing to
identical.
be, dispose of all the matters. Next.
যাওয়ার প্রয়োজন হলে সেদিন চেয়েও যাওয়া যাবে।
Not 17, I am appearing on behalf of the petitioner. This is transferred briefly. Wakalatnama file করেছো?
Yes.
But I have filed Wakalatnama. Here the respondent authority will issued notification on 20th February 2024 for filling up FPS license. Here petitioner in terms of the notification applied. Thereafter area inspector Millard issued notice with regard to an inquiry at her shopcom godown for granting Millard FPS license, which your lordship will find from annexure P2 page 21. Millard, thereafter Millard, the subdivisional controller Millard issued notice on 14 January 2025 Millard to appear on personal hearing. Interview. Millard petitioner appeared. Suddenly, Millard, on first week of February, Millard, the respondent authority submitted a purported and false report stating that the portion of the land where petitioner has erected shopcom godown was belong to PW. But, Millard, your lordship will find from records of rights, it shows that the said land is absolutely alright and belonging to the petitioner. Thereafter, immediately petitioner made representation, which your lordship will find from annexure, annexure, but annexure P4, page 27. That petitioner made representation repeatedly, my lord, for re-inspection of land dispute. But in spite of knowing fully well, my lord, they did not pay any heed, my lord. Thereafter, petitioner came before this honorable court, not with a prayer for holding fresh inspection and to examine the ownership of land. Now, my lord, from this website, my lord, the status shown as rejected, thereafter re-notified. Here, your lordship, kindly come to page 24, my lord, point 58. My lord, after verifying the documents, my lord, they have issued, my lord, notice to appear. My lord, your lordship will, at the bottom, my lord, 58. Whether the applicant is absolute owner, yes. If yes, mode of acquisition, give purchase, inheritance, purchase. Absolute owner or share owner. Now,
Wherefrom you
your
came
lord
to know that your proposed shop come go down over the government land, PWD land?
my lord, they have, my lord, from reliable source, my lord, I came to know that my land belongs to PWD. They said that portion of land belongs to PWD. Not from the, I mean, my lord, your lordship will find from the records of right, your lordship kindly see that I am the owner of the said plot of land.
Where is the record of right?
My lord,
Have you annexed it?
my lord, that, my lord, due to my lord transfer deed, my lord, that was not annexed, my lord. But I have the documents with me, my lord. If your lordship kindly see the, my lord, annex copy.
No, what from you came to know that your
But I have stated in my averment, your lordship, I have
request
stated,
re-inspection? Why?
but I have stated in my averment, my lord. Annex column, annex the column. But I am paying only for, my lord, re-inspection, my lord. But they did not pay any heed, my lord.
Why re-inspection?
My lord, because they said that the land belongs to PWD.
Where they said so?
My lord, no report has been communicated to us,
And
my lord.
you have
That's
placed
it,
the
your lordship kindly direct the, my lord, the authority concerned, my lord, to communicate us.
The report is you have annexed at page 22, I think.
My lord, 22 is not my report.
Inquiry report. What is your name? Sahana Bibi.
Shana Bibi.
Yes, page 22. What is
But
it?
your lordship kindly come to the bottom of the report, my lord.
That I have seen.
My lord, page 25, my lord. Certified that inquiry has been conducted by the undersigned. All the documents have been verified from original by me. Physical inspection is also done by me. And this is the signature of the inquiry officer, my lord, on 7 September 2024.
That time,
But after that, my lord, they said that
how they said, how you know that you have possessed some extra land?
my lord, your lordship kindly, my lord, your lordship kindly, my lord, see the report, records of right, my lord. Kindly.
Understand record of right. Why you such? That the report is very clear. You have your own land.
My lord,
There must have some other ground to reject your candidature.
So, do lordship kindly only, my lord, direct the authority concerned, my lord, to consider my representation first, my lord.
Where is your representation?
Yes, lordship kindly come. My lord, kindly come to my page 27, my lord. I have clearly stated that there is a report of the Amin surveyor, my lord, that Amin surveyor report. Amin surveyor report.
How you came to know about the report of BLNRO? Chachol.
Yes, Chachul.
So how you came to know? Where is the report? There is nothing.
But they did not communicate to us, my lord.
They need not to.
Then lordship kindly direct them to communicate us.
Where is your representation?
Lord, I have stated in my lord, page
Page
27, Annex
page-
P4.
page 30.
Thereafter, repeatedly, my lord, I have made representation to the BL and LRO, and my lord, my lord, district controller, district magistrate. My lord, nothing has been done, my lord. They are pending this matter, my lord. Your lordship kindly consider my representation, my lord.
You encroach some portion of land with your knowledge.
My lord, I am showing one documents, my lord. Your lordship will find from the documents, my lord. ওই documents টা দাও, আমি এটা দাও। ওটা কোথায়? ওটা দাও। রিপোর্টটা কোথায়? আমি Your lordship kindly see the documents, you know. This is the report of the, I mean, that no portion of
I
my
shall
land.
not see the Amin's report like that.
But then your
But
lordship
say
kindly,
inquiry over your proposed shopcom go down.
yes,
You have placed some document.
yes,
They have received your document. You have stated that your proposed shopcom go down is over floor number 369.
yes,
This is a purchase land.
yes,
You have placed those documents.
yes.
Thereafter, they have conducted inquiry and found that I do not know how you have came to know about that, but you have said that you have encroached some portion of government land. You have said that you have encroached some portion of government land. That is the report. But there is nothing there.
কোথায় কোনো ডকুমেন্টস আছে যে পিডব্লিউডি রয়েছে যে ডকুমেন্টস
ওটা আমাদের কমিউনিকেট করে সাবমিট করেছে
But as per instruction from my my junior milord, they said that they did not communicate us, milord. That's why, milord, I have
they have submitted
annexed
the
the document, milord.
They have not communicated to you. They have made the portal that
Lordship,
candidature was rejected. You can ask for them to the reasons. I can relegate the matter to the authority.
Milord, your lordship kindly direct them to file report, milord.
No, report is why is requirement of report filing in this matter. Yes.
Yes, my lord. My lord is inclined to send this back to the authorities for consideration of our
Representation.
grievances and representation.
That is it.
That may be done. That
But
may be
what
done.
is,
On facts, my lord.
find nothing in the report like that. No report is like that.
Yes, yes. My lord, the report which was on the typed report, which was on at page 21 to your lordship. My lord, after that, how the query fell from court is that how did she come to know?
Yes.
The problem is that some mass petition was submitted before the authorities alleging that the road has been encroached. Now, naturally, the authorities carried out an inquiry and, my lord, the petitioner was informed. 29/11/2024 is the date by which she was informed. And, my lord, in presence of the BLRO, my lord, or under the BLRO, my lord, inspection was done. And, my lord, it was found that she was encroaching some portion. And, my lord, that was in January of this year. And, my lord, I also see in the instruction sent to me that in the handwriting of the petitioner, there is kind of an undertaking saying that though she does not know that she has encroached, or she cannot say that she has encroached, she is unsure about that. But if at all she has encroached, she will demolish and then reconstruct, something on that accord. That was her last written, my lord, undertaking. I have it before me, my lord. I can see the soft copy. My lord, unfortunately, we have received this just 10 minutes or 12 minutes back. That is why there is no printed copy of this. So these are the facts, my lord. And I also see, my lord, the 29/11/2024, the, my lord, communication through which the inquiry and everything was, my lord, informed to her. And she knows about this. My lord, I do not know why. I can see, my lord, before, my lord, I am sorry, my lord, I cannot produce the copy right now because just 10 minutes back, my lord, we did not find the time to print this out. But the memo number was 308/RI/Bhado/2024 of 29. Yes, that is the memo number I have just read out. 29th of my lord, November 2024. Inquiry regarding the issue of encroachment of FPS building. This is the reference. Shahana Bibi, Village Chandipur, Bhado, pin number so and so. And my lord, it was
ও বলছে যে
yes.
চিঠি করে জানাই
Revenue Inspector, Bhado Gram Panchayat, Ratua 1 block. He has sealed and stamped and signed this. And my lord, there is also another handwritten, my lord, I can show it to my learned friend over here, the handwritten undertaking which has been given by Shahana Bibi. If I may read out, Ami Shahana Bibi, so and so গ্রাম পঞ্চায়েতের গ্রামের বাসিন্দা, আমি এফপিএস এর লাইসেন্স পাওয়ার জন্য আবেদন করি চণ্ডীপুর মৌজা, দেন ইট গোজ অন, এন্ড দেন my lord, the relevant part, সময় অল্প হওয়ার কারণে দ্রুততার সঙ্গে নির্মাণ কার্যটি সম্পন্ন করি। আমাদের ধারণা অনুযায়ী গোডাউনটি পঞ্চায়েতের রাস্তায়, and this is my lord another thing, my lord, পঞ্চায়েত রোড I have seen, my lord, over here, পঞ্চায়েতের রাস্তায় কোনো অংশ পড়ছে না, তবে আমাদের ভুলবশত যদি গোডাউনটি রাস্তার জায়গায় পড়ে থাকে তাহলে আমরা গোডাউনটির যতটা অংশ রাস্তাতে পড়ছে সেই অংশ ভেঙে দিয়ে পুনর্নির্মাণ করে নেব। This stance, my lord, is absent in the petition, my lord, subject to correction, my lord, by my learned friend.
Let them file, my lord. Then let them file report. I will file reply, my lord. If that be so, my lord, I am not aware, my lord.
Your petitioner knows everything.
Yes.
That's why
Let your lordship kindly direct them. Let your lordship kindly direct them to file a report, my lord.
what is the I know
Purpose,
whether
yes.
the petitioner is clear, whether the petitioner appear before this court under the clean hand. That's why I
That-
want to know.
That I at the beginning that I
Appears
have
the petitioner not approach this court in clean hand.
that
That's why I want to know how she knows about the encroachment. Nothing is there.
but if your lordship kindly direct them,
If you want to challenge the everything, every report, everything, I can relegate the matter. You can
Yes.
take appropriate steps about the report and everything. Otherwise, in the before this read code, you have known. You have
And my lord, I also see that on the date of inquiry, physical inquiry, she was also present.
yes.
She was also present with, along with my lord, her family and few
kindly all
local
this
people.
will be taken, my lord, on filing affidavit, my lord. I will file reply, my lord.
No, that
Lordship kindly give me one
Not
chance,
be
my lord.
required, my lord.
not required now.
Unnecessarily, it will be prolonged.
If you want to challenge this according to the law, you can challenge it.
Mm.
Then you have to go to. I relegate the matter to the authority.
Yes.
To the SCFS, you got all information, everything.
Lord, I am only praying for consideration of my representation.
How you can be considered when you are encroaching a government land?
But then let them file affidavit, my lord. I will file my reply, my lord.
Then that's why I am relegate the matter to the.
Yes, that
SCFS.
will be probably the best thing to do, my lord, with
That will be
deepest
the
of
best
respect.
for you also.
Yes. Yes.
Otherwise, if it appears you are appearing before this court with
But this is
unclean hand,
transfer with
that
my lord.
straight away that would be rejected.
But transfer with my lord, I am at the very near beginning, I have my lord, made a prayer before your lordship that transfer with my lord.
That's why I am not rejecting like that.
And she will also have an order against which, my lord, I will not further advise, my lord. I cannot, I should not.
Very good. Please take down.
But in the meantime, my lord, one prayer I will make.
No, no,
But
no
no
such, no
vacancy.
such. You know the very rule is very. You know the rule.
Yeah, then interim order to the board.
Petitioner applied for license in terms of vacancy notification number. Vacancy notification dated. Petition, কি বললাম? Petitioner applied for license of MR dealer in terms of vacancy notification dated 29th of February 2024, issued by SCFS Chachal. After her application was accepted online, her proposed shop-cum godown was inspected by the inquiry team of concerned FPS on 7th of September 2024. Full stop. However, the inquiry team has submitted a report and the petitioner was called for a personal interview by concerned district level fair price shop selection committee. After such personal inquiry, through a credible information, the petitioner came to know that SCFS Chachal, no, that BLN LRO Ratua 1 block has conducted a physical inspection over the proposed shop-cum godown of the petitioner and is of opinion that 3 to 4 feet of such godown has encroached on PWD land. She submitted a representation to the district controller regarding the inaccurate report of BLN LRO Ratua 1. His representation was not considered. He again wrote a detailed representation to the department on 11th of May 2025. Her representation was not considered. Hence, Learned Counsel, appearing on behalf of the state, submitted that there are a mass representation to the department by the local people regarding encroachment of the petitioner in respect of his proposed shop come go down. Encroachment of petitioner over government land in constructing proposed shop come go down. The matter was inspected by the concerned BLN LRO in presence of the petitioner. The petitioner was intimated regarding the fate of the inquiry by a memo dated 29th of 11/2024. Thereafter, the petitioner made a written undertaking that if any portion of her proposed shop can go down was constructed over government land, she shall demolish it and shall again reconstruct it. Full stop. Considering the entire circumstances and the facts narrated herein, it appears to me that the petitioner has raised objection about the report conducted by about the report of BLN LRO Ratua 1. Full stop. It is the further contention of the petitioner that no portion of proposed shop can go down of the petitioner has encroached the PWD land. Disputed question of fact arises. Thus, I think it necessary to relegate the matter to the authority concerned to dispose of the representation of the petitioner. Accordingly, the incident writ petition is disposed of, directing the subdivisional controller food and supply being respondent number 7 of the incident writ petition to dispose of the representation of the petitioner dated 11th of May 2025 within 6 weeks from the date of passing of this order. No.
But instead of 6 weeks or 4 weeks,
date of passing of this order, after giving a reasonable opportunity of being heard to the petitioner. Full stop. I make it clear that the petitioner shall communicate the order along with her representation to the authority within 7 weeks from the date of passing of this order. Full stop. I also make it clear that this court has not entered into the merit of this matter. Respondent number 7 shall dispose of the representation according to the law without being influenced by any observation of this. Since no affidavits exchange between the parties, the allegation made in the writ petition shall be deemed to have been not admitted. Upon likhit affidavit filed on the petition is taken.
but instead of 6 weeks, and we are pray for 4 weeks.
6 weeks is before puja, no issue.
Your Lordship kindly, my lord.
4 weeks is not possible. You have to be again came to this court for violation of the order like that. 4 weeks you are given 1 week time.
But then 5 weeks, my lord. But then 5 weeks.
Within 6 weeks from the date of passing of this order, and you are given 1 week. That means 5 weeks is there only.
Get through.
With the authority. Next.
এটা কি ওইটা যেটা তোমার ওই
without interview. Without interview. In this matter, my lord, I am for the petitioner. Last action, my lord, was pleased to direct my learned friend to file a report.
না না হয়ে গেছে জাস্ট may I clarify only one thing? My learned friend is relying upon a notification whereby he is saying that everyone has to call for an interview. if your lordship kindly take a trouble to see the notification once, notification speaks for itself. It is the discretions of the millet, the authority to call for. Millet, I have prepared the report. If your lordship so desire, I can file it tomorrow because it is lying with my junior millet.
Come on tomorrow then.
Yes,
Tomorrow I'll take the matter in the first half.
yes. I will take kindly.
Not today.
Very well.
Next.
I am for the petition.
আমি লিখছি
The vacancy declared on lordship 20th, lordship on 20th June 2024. Rajgram, Murarai, Birbhum,
পেজ নাম্বার
and place page 22. Central location, Kodampur, Rajgram, water tank. This is very important. Pursuant to that, the petition applied for the said post next
You're supposed to file one supplementary affidavit today.
দেওয়া হয়ে গেছে
Yes.
লাস্ট দিন দিয়েছেন
Last already
You have already handed it over.
and the copy has been
Well, we have
Yes,
got the copy.
supplementary.
Yes.
Yes, what is the case about? What is the matter?
Yes.
Lord,
The inspection did come to the Millet spot. My position is the location is the location spot near to the location spot.
Take the mic,
And-
take the mic. I cannot hear that.
My plots which was annexed people with ships kindly can
Applied for license.
yes
For
yes.
location,
location near to the spot and big shop room and go down.
what is the notification? What is the location in the notification?
Notification lordship kindly page 22.
Yes.
Got it?
It is Rajgram. Central
Yes,
location.
yes. Kodampur near Millet
Rajgram
water tank.
Yes.
Lordship got
What do you want to say?
Millet inspection was completed. At the time of the inspection, they were very much satisfied of the godown and shop room
Yes.
and nearest place of this place. Millet, thereafter interview was called up. I appeared to the interview and come to know the respondent 5 also applied the said interview. That location is far from this place. Far from the place
That
and
location
very
is the
small.
Shop come go down of the private respondent is far from the location.
Place and so little and so much small. And and come to know lordship. After the interview, his name was selected.
Okay.
Selected for the
Granting license.
yes. Lordship kindly come to the page annexure 3. Lordship kindly see. Lordship kindly
What
3.
is the status?
For a
License granted?
Millet, may I just indicate only one thing? Millet, the entire case of my learned senior friend is based on the Millet paragraph 5 of the supplementary affidavit file. Kindly have a look into that, Millet.
Supplementary affidavit?
Supplementary affidavit.
I come.
আমাকে জিজ্ঞাসা করছি
Okay.
আপনি বলে দিন
Got it.
Now, in the paragraph 5, he has stated that the respondent number 5 has forged the documents.
Yes.
And by practicing the fraud, he has obtained the license.
Lordship.
This is the submission and the genesis of the matter. Now, my proposal to hear it, the read code lordship knows far better than I do, cannot go into that disputed question of fact. Now, what I am proposing, he basically, if I take it in one hand, he is an unsuccessful candidate coming up and by filing a supplementary affidavit, he has somehow improved his case. If it has been found to be true, then this notification or the successful candidature has to be cancelled.
Yes.
This has to be done by subdivision controller or the Miller
By the
district
authority
controller authority. So Lordship kindly directs Miller to make an inquiry to that extent, and if found to be true, they will take action in accordance with the law. Because today, if I come up with the report or otherwise,
that will be
this
done
is
by-
absolutely futile exercise.
So whether there is any detailed representation?
Yes, yes, Lordship kindly see.
Representation.
Lordship kindly page 33. Lordship kindly come to that.
Page
33. Illegal appointment of Bilkis Begum, wife of Majibul Islam, village and post of Rajgram police station, Muraroi, district Birbhum, pin number such and such, ignoring the inquiry report of the inspection team and the main of the area of the shop room and nearest place of the said shop room, with influence of the material uncle, those who are the post holders of the ruling political party of the district. The offer letter informed the Bilkis Begum and directed the department not to give any effect the FPS license and to conduct further inquiry, and also the request to cancel. Further inquiry and request to cancel. And Miller points has been given in next page, and Miller last page 35 is concluded. Miller, my sub and Lordship kindly come through the Miller supplementary route. These are very funny things. And what is illegality has been done. I've showed to your Lordship. Subsequently, Miller right collect. Lordship, in my supplementary route, Lordship, kindly come to the Miller annexure, page 8 of the deed.
Page 8.
8, Lordship.
Yes.
That was page 8 of the supplementary route.
This is a part of a Heban
Yes.
Madoli. Yes.
Lordship, just a minute, Lordship. One. Miller, page 6. Lordship, kindly P5. Hebanamal.
Yes.
Lordship, the deposited of this Miller deed on 22nd August and 2005, 4. And Miller registered 24. Registered on 2nd September 24. Very well, Lordship. 24 Miller. And Lordship kindly come to the visit. Very funny things. Lordship kindly come to the Lordship. Page 18, P6. Millard, before that registration, the ROR was completed in the name of the respondent 5. Lordship got it? On 27/8/2024. Khotian Toiri Tarik. In the name of the Bilkis Begum. How it is possible not? Before the registration, the Millard ROR is completed. And now Millard, another funny thing, Lordship. She is applied, I came to know, the respondent 5 applied for the said post on 16th, 2nd April. No. Yeah, Lordship on 16 September. The Millard total gap from the registration 14 days. How it is got the permission of the panchayat for construction of the building? This is the Sali land, agricultural land. How they got the permission from the panchayat and how she's constructed the building and it's completed everything. My question is this: within 14 days from the date of the Millard registration, how it is completed within 14 days?
You are challenging the
And
prompt
Corbaser has
action.
been.
You are challenging the prompt action of the state authority. No, if
But-
you where is your point regarding the fraud and fraudulent document like that.
Yes,
That
yes.
is supplementary affidavit, page paragraph 5.
That is the thing.
But this I have
Where is
seen
the
the-
documents? like-
Yes, correct. But this is no supporting documents to the annexure. But may I just pointing out only one thing? Lordship kindly take trouble to see when the advertisement was started. It was 20th June 2024.
Yes.
Right? Now, many things has been stated against me, Millard. So I have a little chance to respond. And when this was affirmed, this 20th day of June 2025, in between 1 year was in a deep slumber. I'm asking myself, had it been a case that there is a illegality or arbitrariness caused by any of the department, and it is came to his knowledge, now he has come in the belated
As
stage.
on when, Vinod, I come to Millard,
Now in a
after
one
the
after 1
license.
year.
When I came to know, she obtained the license. His name was recommended. Then I came.
No, you have only challenged that the action was taken by the state impromptly. That is only the issue.
No,
You can raise the construction within 10 days, within 7 days.
no,
Whatever
my
the-
son, conversion has completed Millard, on that time. How to come? Millard, it is possible from the sunny land. This is agricultural land. Lordship, kindly see the deed of the Heva. It is agricultural land. And Millard completed the Millard 2nd November.
No, I understand. No. That matter cannot be relegated. It has to be disposed of here.
Lordship,
I find nothing regarding the.
Yes, there is
like that.
nothing. And if your lordship kindly takes trouble to see, their supplementary affidavit once again. Kindly take trouble to see. Have you got lordship got 8 minutes? Kindly come to page 20.
Yes.
The lordship would see the order passed by the competent authority and what is the
20.
no objection is filed against the claim of the applicant is respect of the mentioned plot. The request fee has been deposited. The land is not vested in the plot. The petitioner in possession of the scheduled property. So the prayer and the petitioner is qualified to be allowed. When this was allowed, it was allowed on Millard 27 August 2024. It is well within the time. Lordship knows the judgment, Millard. Prior to Millard issuance of the same, if I could do it, there is no illegality. There is nothing. He has come up with the Millard so many things. There is something has been done, something wrong has been caused. Where is, I am asking myself, where is the Millard the supporting evidence to that extent?
As
There is
such,
nothing.
Millard, the representative has been made. Stating all these points, Millard.
Submit a report, detailed report. Otherwise, nothing can be done in this fashion.
Millard, may I just only indicate one thing? Millard, I will definitely.
Lordship, earlier occasion also that to submit the report.
No, if I cannot come up with a piecemeal basis. I have to give the reply to the main writ petition, then he has come up.
Supplementary.
Yes. Now I have to incorporate the entire things.
Yes. Very well.
This, if I come up with the report
What
even,
is the status now? He is running the business.
he is running the business.
Okay.
Beneficiary has been allotted.
Okay. So today there is no such chance of.
No, nothing.
No.
Like that.
No, not now. Not now. He is obtained the allotment till that minute. After filing this case, after this order minute, they stopped. Lordship passed an order on 6th minute. 6th minute. After that, it was
I have not passed any interim order like that.
Lordship
No,
passed any-
there is no interim order.
Nothing. No interim order has passed.
No, on that time, no interim order. After they stopped them, all these things. No allotment has been given
No, I have
as
not-
yet.
How they have stopped there, that is their issue. I do not.
That is something different. But if your lordship kindly take trouble to see once more to the prayer portion. Prayer portion is that you cancel the same and give it to me. It cannot be.
No.
It
Further
cannot be.
inquiry,
It cannot be because
So, Millard,
if it has been cancelled.
also,
the
Millard,
entire
Lordship,
practice will
kindly
be cancelled.
see
We have
my
to-
father, Millard, request
Sir,
before Lordship,
the right
submit
time.
to Lordship.
A report, otherwise.
This
today
cannot be.
I find-
Lordship, in the meantime, Lordship, not to give it any allotment.
No, there is no.
How this can be?
There is no such merit.
Millard,
like
if
that.
allotment has been given, Millard, pending of this case, Millard, how does Millard will be
Where is the prima facie, sir?
No,
No
that
prima facie-
illegality has been done, it is clear.
How illegality done? You have
That
saying.
the land, this land, and also that land also, I see it, your lordship, that land also belongs not of that person's. This is the third person land. This land was Heba, is a forced, and the case is pending before the Ramprat court against that land. In
Civil suit pending?
disputed land.
Civil suit pending?
Yeah, suit
Is
pending.
there any civil suit pending?
Pending in the Ramprat court.
Contest the civil suit where before this writ court.
And
To get the order, everything would be turned out.
this.
You have to show a strong prima facie.
No, I am not party. I am not party.
You are not party.
I am not party. This suit, beloved, the Bilkis Begum, who is obtained that
Okay, I have heard. I have heard.
obtained this that land. This is the false.
Okay, okay,
False beloved deed.
okay, okay.
Just a minute, I saw to your lordship. We did the কোথায়? We did the next deed. Next deed কোথায়? এটা এটা কেন কি আশ্চর্য I saw so to your lordship, this case is pending before the Rampart Civil Court. In case number
This
1.
is a registered deed. At this juncture, prima facie, it has some evidentiary value. Registered deed. Today, you can challenge this on your way, but registered deed
Minute.
has some.
Only Hamid submission before lordship.
You can challenge it with saying that with the
How it possibly beloved this land beloved, which was beloved donated by Heba Bilawas, Heba deed. Beloved, on second beloved surveyed copy of the deed. Yes. Lordship kindly see, and also lordship kindly see the deed also. Had that more trouble beloved in an exterminate of this my subdivision bit. Lordship kindly further more. Yes. Yes, lordship. Lordship kindly see. এখানে কোথায় গেল এটা? আচ্ছা। মফিজুল ইসলাম, মর ইসলাম, বিলকিস বেগম। ডোনার গিয়াসউদ্দিন শেখ। Lordship, first, second, third line, Lordship kindly see. রেজিস্ট্রিকৃত 21/5/2088 নিম্নে তফসিল সনের 4554 নং দলিল মূলে Lordship kindly see. Lordship kindly see my দলিল মূলে Lordship kindly see this deed beloved. Deed beloved. That deed beloved উপরে একদম উপরে দেখা that deed beloved in the another name, that number at the top 4554 নং দলিল মূলে প্রাপ্ত 4544 নং দলিল মূলে প্রাপ্ত ফরজারি মানে ডকুমেন্টস beloved this third person beloved is the owner. Subsequently, that was collected, that's why I am not annexed.
What are you saying?
Staying before the staying before the registration, the R1 was completed. How it is possible? In the name of the respondent 5, all are illegality and all has been done. Within 14 days, structure and conversion has been completed.
Very well. You can challenge this according to the law, and I delegate the matter to the authority.
That is what I am saying. That is what I am proposing from the very beginning.
Please take down.
আমি তো বলছি
Petitioner applied for license in terms of
Lordship.
APS notification dated 20th of June 2024 issued by SCFS Rampurhat. His proposed shop come go down was inspected by the concerned inspector. He appeared in the personal interview. Thereafter, he came to know that private respondent was selected for the said license, and the private respondent was selected, and license was granted in his favor, in her favor. It is the contention of the petitioner that the private respondent cannot be appointed to run the FPS license by the concerned authority. He made a detailed representation and his complaint against the against the candidature of the private respondents on numerous grounds. Full stop. The petitioner, by filing a supplementary affidavit, has also categorically raised a point that private respondent has submitted some forged documents, thereby defrauded the respondent authority. On that ground, it is on that ground it is the contention of the petitioner that the candidature of the private respondent is required to be cancelled. Mr. Sumon Sengupta. Learned senior government advocate, appearing on behalf of the petitioner, submits that, appearing on behalf of the respondent, state respondent, submits that the petitioner has raised some objections and complaints against the private respondent, which contain deliberation by the which required to be verified or considered by the respondent authority. He further submits that this court cannot go into the merit of factual aspects which was raised by the petitioner before this court. Yes, what is your submission?
Well, I am for the respondent number 5, madam. 2 persons, madam. Same area has been applied for the same course. And selected by the concerned authority after complying all documents, all formalities. Thereafter, I have been selected and I am running my business.
Okay.
Running to continue my business.
রানিং ঘটছে তো বেনিফিশিয়ারি অ্যালটেড হয়ে গেছে তো বেনিফিশিয়ারি অ্যালটেড হয়ে যাওয়া
Learned counsel appearing on behalf of the private respondent submits that the present petition, the private respondent was selected by the concerned authority after concerned authority selected by the concerned authority after complying all due formalities. He submits that the license was granted in favor of the private respondent and he is now catering the business in the locality. Having heard the learned counsel for the parties, considering the entire matter, it appears that the present petitioner has raised some serious question against the candidature of the private respondent who was selected by the respondent authority. The objections regarding placing forged documents by the private respondent as well as the other objections can only be only be considered by the, cannot be considered by this court as the factual matter is involved therein. Considering the same, I intend to relegate the matter to the concerned authority to dispose of the grievances of the petitioner. Under the above observation, the instant deed petition is disposed of, directing the respondent, subdivisional controller food and supply Rampurhat, being the respondent number 4 of the instant deed petition, to dispose of the representation of the petitioner dated 24th of June 2025, being annexed P3 of the instant deed petition, by giving reasonable opportunity of being heard to the petitioner as well as the all concerned. I make it clear that the petitioner shall place a detailed representation to the subdivisional controller food and supply concern within 2 weeks from the date of passing of this order, along with any document he intends to rely. Full stop. The subdivisional controller concerned shall dispose of the representation within 6 weeks from the date of receiving of such representation from the petitioner, by giving a reasonable opportunity of being heard to the petitioner, private respondent, and all concerned. I make it clear that this court has not entered into the merit of this matter.
Obliged, your lordship.
Concerned subdivision controller shall dispose of the representation according to the law without being influenced by any observation of this court. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been
My lord.
Only on another submission, lordship.
the decision of the authority shall be communicated to the petitioner within 2 weeks after taking such decision.
For the information before the court minute, I am submitting before lordship. This is the cause no business has been running. He
I
said
have
that.
taken note of his submission only, nothing more.
Yes, yes.
I have taken note of his submission only. Nothing
But
more.
edit did it.
Yes, it is.
Yeah, sure.
Next.
I will like. That was taken on the last occasion, and you also was pleased to direct me to serve a copy of the writ petition upon the private also directed the
Insufficient address.
insufficient address, but
So
I
what
have,
we have done?
I have served.
Again insufficient address.
Again the same. But you also was also pleased to direct the state respondent to intimate the private respondent.
Who is appearing?
One is appearing.
তপতি সামন্ত শ্রীশান্ন বন্দ্যোপাধ্যায়। Intimate them.
Inform.
Come on next week then. Though petitioner has served upon private respondent regarding the regarding.
Oh, my lord, I am appearing for the private respondent.
You are appearing on behalf of private respondent. Very good. No, not to part. Very good. Private respondent has appeared, so we can hear it out. When? Next week.
As well, also.
Let the matter appear next week, Monday.
As well.
Monday. Affidavit of service right now. Next week. আচ্ছা একটা নোট করুন affidavit of service filed on behalf of the petitioner will be taken on record. Mr. Dhara represents the private respondent. Let the matter appear in the list on 26th of August 2025 under the same head. Next.
I am for the petitioner, my lord. I have, my lord, served, my lord, including the private respondent, my lord, affidavit of service, my lord, in my senior brief, my lord, copy is here, my lord, also serve the notice thereafter. After mentioning, my lord, I serve the notice also, my lord.
You are for the state. Yes, what is the matter?
Matter is that, my lord, as per notification, my lord, the petitioners applied for the fair price, fair sub dealership, my lord. My lord, petitioner complied all the formalities, my lord, but petitioner was not selected. They have selected the private respondent. But as per my lord, the proposed notification, my lord, they have not fulfilled the criteria, my lord. Kindly come to my lord, your lordship, kindly come to the notification essential, my lord, the essential criteria, my lord. Kindly come to my lord, page 25. My lord, the requirement, my lord, 4, my lord. 4. Required size of godown and shop for running the ration shop, my lord. That criteria they have not complied with, my lord. I have specifically
Down 300 square feet.
yes,
And
along
cover
with my lord.
space, shop room 100 square feet.
Yes, my lord.
This is the criteria.
Yes, my lord.
What do you want? What
My lord,
is your
they
objection?
objection they have not. They have not.
They
the
don't have such area.
yes, my lord. Yes, my lord.
So where is the evidence?
Evidence kindly my representation, my lord, and my lord, I specifically stated, my lord, they have not done they have not the set criteria, they have not completed, my lord, they have not answered it, my lord. Kindly see, my lord, page 39, my representation. Very next day, my lord, they have
The status. What is the status?
status, my lord, till date they have not allotted. Work order was not issued, my lord.
Selection has been made.
Yes, selection has been
License granted.
yes, license granted, but work has not started, my lord. Kindly come to my lord. My specific that point, my lord. Nothing, my lord.
Yes, what do you
Only
want?
they have submitted report. Whether my lord, I have, my lord. My lord, kindly come, my lord. Kindly come, my lord. Page, my lord. Page, my lord. I have annexed all my documents, my lord, including my lord, sketch map of my go down also. Kindly say they have, my lord, submitted report annexing. They have essential, my lord, documents, my lord. I have nothing, my lord. I written from the here.
You have the objection that the private respondent had not the required area of 300 square feet of godown.
Godowns,
100 square
square
feet
feet
of
of
shop room.
shop.
This is only your objection.
Yes. Kindly come to
And
page 39.
You have the size.
Yes, my lord. And my lord, they have come to my spot, inspected it, and my lord, offer letter was my lord, thereafter, my lord, I have called for, I present along with original documents, and my lord, thereafter, my lord, they have not issued it, my lord. Only, my lord, this point, my lord, nothing, my lord.
So this matter cannot be decided without filing any affidavit like.
In the meantime, they will, my lord, allocate, my lord. At least, my lord, Tata, my lord, as on date, my lord, they have not issued.
You have just said it. Nothing has been shown anything.
My lord, I have not.
Good prima
My lord,
facie
this
case
is not
to
this is not a, my lord, documentary evidence, my lord.
If it appears later that he has private respondent has no such size like go down or like that, his cancellation can be
Their
done.
document, my lord. Their document, my lord. I have no any document in my hand. My lord, in their custody, my lord, all the documents, my lord.
Yes, let them file a
Allegation
report.
was made, my lord. Yes.
My lord, may I
Yes.
subject to my lord's approval. My lord, what is this case, my lord? Allegation, so far the case state is concerned, that the private respondent in whose favor the license was granted, he didn't have the requisite qualification
Yes.
as per the terms and condition of the tender. Well, now I first I put that question to myself in a writ jurisdiction. Well, it knows that there is a distinction between the plaint and the writ petition.
Yes.
In the plaint, no evidentiary value is required to be, my lord, annexed or stated. Only the points, pleadings. And in the writ, there should be some prima facie evidence.
Yes.
This is the, my lord, distinction. My lord knows that this is the this is the Honorable Appeals Court judgment. And very well, it has still it has been upheld by the Honorable Appeals Court in the latest. So, my lord, my consideration, my lord, first, my lord, before inviting us, my lord has power. Not I am not saying, but first he has to establish the prima facie case that his allegation has got some merit. And what is the documents? He has to submit some documents. So, my lord, if I come, he has participated in the selection process. He failed. There another angle, my lord, kindly consider. If somebody participates in the selection process,
Unsuccessful candidate.
yes, my lord, after that, he cannot challenge, my lord, can kindly consider, provided he has to satisfy first prima facie that there is some document, even one evidence that shows the action of the state respondent is contrary to the rules or guidelines or whatever statute. My lord, here, my lord, they failed to, my lord has made that observation is clear. My lord, I think, my lord, in this facts and circumstances, one can, my lord, can at best can do, my lord, whatever representation he has made, that can be considered by the subdivisional controller. That much at best. However, I am saying he is not entitled to get any relief from this order.
What is the predicament of them, my lord, to produce this
No,
document, my
this
lord?
is not
This
my.
is a read code, my
The
lord. This is a
onus-
read code. Court
No,
has the
no,
power,
this
my
is
lord,
the
to
read
verify
code.
the
That's why.
document. Verify the
This is
document.
the
They
read
have
code.
mischief it.
That's-
They have mischief it.
Come on after 2 p.m. I have some matter. Thereafter I will take up this.
Yes, my lord. Yes, my lord. Court has a power, my lord.
After 2 p.m. I have some fixed matter. Thereafter I will take up this matter.
All right.
After 2, let the continue with the
No, 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 no.
2 p.m. I have some fixed matter.
Fixed matter.
Thereafter I will continue with the list.
the next matter, Lordship, kindly pardon me, Lord, another matter, I have a fixed matter. Lordship, kindly
I have
pardon. My
fixed
junior will
matters.
be here.
The fixed matters will taken up at least half an hour or more.
Oh, wow.
Thereafter I will take up this matter.
My lord, item number. My lord, item
Not
number
now, after
56, my lord.
না আগে
চলবে আগে
এটা তো আগে
For the list.
I am for the petitioner. My lord. We have concluded our submission and attorney is required to address the case. Matter relates to our age bar in the entry point of the dealership business.
Yes.
Your Lordship,
Short-
I'm on behalf of the state, Your Lordship. Your Lordship, kindly keep this matter any day as per Your
The
Lordship.
fifth
convenience.
occasion, my lord.
Yes,
What-
I am fixing this matter today.
In their
What's the
presence.
day?
Lordship, Learned Advocate General is engaged in some another court.
He has cases, he will appear in other courts, but he will not appear in this court. This is also not fair.
However,
I have to face the client also.
a specific date.
Any day as per Your Lordship.
Today
convenience.
is the day. If I fix tomorrow whether it is possible for the Learned Advocate General to appear,
He's
take proper instruction.
I have taken proper instruction, Your Lordship, but he's engaged
I
before.
know he is engaged.
But
but-
he's engaged since morning, Your Lordship. That is why I'm. I have taken instruction.
My lord, let it be passed over for a moment. Let she take the instruction and submit.
I have
Instruction.
taken instruction, Your
If
Lordship.
I fix in the next week, what would be the proper date at 2 p.m.? Okay.
I'll come back with
Yes, you come back.
that.
You
Pass
come back with
Grateful.
proper instruction.
Pass over.
If it is possible, in the next week, starting from 25 to 27. 25 to 27. 3 days. Sunday, Monday, Tuesday, Wednesday. Any day at 2 p.m.
25, 26, 27 মধ্যে যেতে
What would be convenient for Learned Advocate General? Okay. Take instruction. Pass it over.
হবে।
Next.
I am for the petitioner. This is Advocate General is appearing in this matter also.
This matter also Advocate General.
Indranil Rai.
Indranil Dey.
না না অন্য নাম বলছি তো ভুলভাল ইন্দ্রনীল দে also Advocate General. This is related. My lord, kindly take note of, my lord. This is a case where, my lord, division bench almost settled the issue.
Which matter?
The cost price and the
Okay.
that matter.
Okay, I understand. This
We are
matter,
suffering every day. Suspension order is being issued on that ground. Huge money is due and payable. Admitted position, division bench already.
I also pass it over. Let the take
My
the
lord.
instruction.
পাঁচটা আমাদের পাঁচটা আমাদের 6 I am for the petitioner, my lord. 6 and 7, your lordship may remember that matter is, my lord, replenishment of the food grains.
Yes.
Mr. Sonal Sinha already concluded her submission.
Yes.
I shall give reply.
Yes.
Your lordship may take up the SP Kundu matter first. There are two matter.
Give me
One
the
is-
item number 7.
Yes. SP Kundu, not the Shaktipada Kundu. Thank you. Miss Sinha appeared in this.
Yes, Miss Sinha. Yes.
But just brief facts I am stating. 2 licenses has been issued in favor of the partnership firm. One in the name of, my lord, SP Kundu and brothers, and another is, my lord, Shaktipada Kundu.
Yes.
So far, SP Kundu and brothers, item number 7 is concerned. That is in the municipality area of the Arambagh. And so far, my lord, Shaktipada Kundu is his operational area is the panchayat areas. So if you are kindly first Shaktipada Kundu matter, where Ms. Sinha is appearing, kindly turn to, my lord, page 16,
Page 16
my lord,
of
This-
writ petition.
of the repetition. This is the license I can show to your lordship. This is SP Kundu and brothers. Can you read the 4th line from the top? SP Kundu and brothers. Have your lordship got? And other one is, my lord, Shaktipada Kundu.
Yes.
But due to devastating flood in the year 2015, the entire Arambagh block were waterlogged And accordingly, my lord, the executive officer, Arambagh Municipality, instructed the subdivisional controller, Food and Supplies, Arambagh. এই 500 বার করেছে জেনে আসতে বলেছে
ঠিক আছে
500 বার করেছে জেনে আসতে বলেছে
ওই নেক্সট উইকে
মানডে
ওই বুধবার রাখি
রাখি না জশটা বলে ফার্ম রেট দিতে তুই জেনে না আসুক 500 বার আরেকটা ব্যাপার আছে তো ব্যাপার
কোনটা
অ্যাডভোকেট জেনারেল এক কাজ
সেভেনও আছে
পড়ে
না না চারটে তাহলে জেনে আসবো তো
জেনে আয় 500 বার করে সোম মঙ্গলপুর মঙ্গলপুর জেনে
এটা সিক্স সেন্স দাদা এটা তোমার
আমি পরেরটা করছি এসপি কুন্ডুটা করছি কাইন্ডলি টেক পার্লার পেজ 17 This is issued by the Executive Officer, Arambagh Municipality, addressing to the Subdivisional Controller, Food and Supplies, with the request for supply rice to feed the food affected persons, Arambagh Municipality. I am to request you to supply 20 metric ton rice for feeding the flood and rain affected people of Arambagh Municipality. In the emergency situation, I request you to supply the same on free of cost. Hope you will extend your hand and help us to cope up soil. So, this has been issued, kindly see Executive Officer of Arambagh Municipality.
Yes.
And received by the Subdivisional Controller with seal and signature, middle portion, bottom.
Yes.
But in terms of this direction of the Subdivisional Controller supervision, kindly turn to my lord, page 19. I delivered 20 metric ton of rice for the flood affected people of the Arambagh under the jurisdiction of Arambagh Municipality, which will appear from page 19. On the same documents, receipt has been acknowledged by the Executive Officer. Page 19, this is dated 2nd August, received on 2nd August itself. Due to emergency situation on the very same day, I have supplied 20 metric ton. So for the other matter is concerned, I have shown to your lordship 30 metric ton is due and payable. So for the Panchayat area is concerned, that has been issued by the Panchayat Samiti. Kindly turn my lord, page 19. Left hand side received 20 metric ton of rice on 2nd August 2015, endorsed by the Executive Officer, Arambagh Municipality. Now, your lordship, kindly turn the page. This is also an acknowledgement issued by the Vice Chairman after receiving 20 metric ton of rice for the flood affected people of Arambagh Municipality.
Yes.
Now, your lordship, kindly come to page 23. Now, this is a communication of the subdivisional controller addressing to the district controller Food and Supplies on 13th May 2020. Request for replenishment of 20 metric ton of rice to Messrs. SP Kundu and Brothers, MR Distributor, Ghumhati, Arambagh, Hooghly. This is to inform you that Messrs. SP Kundu and Brothers, Kontai, Arambagh, supplied 20 metric ton of rice to the Arambagh Municipality in the year 2015, as was required for doing the food and rain affected people under Arambagh Municipality. As per the letter issued from this end, from the end of the Arambagh Municipality, with request to the concerned distributor treating the emergent arising out of the criteria situation in so and so, the stock of, second paragraph, the stock of 20 metric ton of rice was received by the Executive Officer and the Vice Chairman, Arambagh Municipality, as is evident from the copies of the receipt duly signed by the on 2nd May 2020. The letter issued from their end, either the enclosed herewith for a ready reference favor of your kind perusal. In view of the above, the pair of Messrs. SP Kundu and Brothers, MR Distributor, Arambagh, for replacement of 20 metric ton of rice and making good of their sufficient stock arising out of the situation due to COVID-19 is forwarded to your end for your kind consideration towards replenishment of the stock of rice. Now, your lordship, kindly come to the earlier page, page 22. Not annexing this document, I wrote a letter to the District Controller Food and Supplies on 12th of May 2020. Kindly see the date right hand side top. Addressing to the District Controller, Bonna Jone Tarner Chal Firot Paibar Jonno Abedan Potro. Reference memo number so and so, dated so and so. মহাশয়, আপনার অবগতির জন্য জানাই যে আমি শ্রী মুক্তিপদ কুন্ডু, মেসার্স SP কুন্ডু অ্যান্ড ব্রাদার্স, গৌরহাটি, আরামবাগ, হুগলি একজন অংশীদার। 2000 সালের বন্যার জন্য আমরা 20 মেট্রিক টন চাল আরামবাগ মিউনিসিপ্যালিটি অফিসে দিয়েছিলাম, যাহার মেমো নাম্বার so and so আপনাদের অর্ডার অনুযায়ী। কিন্তু আজ অবধি 2000 সালের বন্যায় দেওয়া 20 মেট্রিক টন চাল এখনো আপনার নিকট হইতে পাই নাই। বর্তমানে কোভিড-19 পরিস্থিতি যেভাবে চাল বিতরণ করা হচ্ছে এতে আমাদের 20 মেট্রিক টন চাল মজুত না থাকার খুবই অসুবিধার সম্মুখীন হতে হচ্ছে। বিতরণের বিশৃঙ্খলা সৃষ্টি হলে আমরা কোনো প্রকার দায় থাকিব না। অতএব মহাশয়ের কাছে নিবেদন যাতে আমরা 2018 সালে বন্যার ত্রাণে দেওয়া 2015 সালে বন্যার ত্রাণে দেওয়া 20 মেট্রিক টন চাল খুব তাড়াতাড়ি ফেরত পাই তাহা সুব্যবস্থা দানে আয়োজিত করিবেন। Enclosure municipality order copy Xerox, subdivisional controller order copy Xerox. Both has been enclosed. Now your lordship kindly take up the report submitted by the state affirmed on 2nd April 2025 because there are two reports, one report and another supplementary report. Mr. Srinivas, next Monday, Advocate General will be available at 2 p.m.
Next Monday.
Both the
I
matters.
just had a talk with the হ্যাঁ ওখানে চলে যান কোনটাতে ওই ক্যাবে এটা তো আমরা পরের দিনকে বলি
কোনটা
আমরা তো এখনো ইউনিয়নটা তো তোমার যেটা 4 নম্বরটা
হ্যাঁ ওই দুটো তো আছে
আছে এটা অন নম্বরে তো হ্যাঁ ঠিক আছে
2 and 4 both are 25th. She has also come, my lord, after taking instruction from the London.
Monday. Monday, that means 25th.
At 2 p.m.
At 2 p.m.
25th, 2 p.m.
Well, kindly record something at least, my lord, so far my clients are concerned.
No.
One pair of the Advocate General.
Item number 2 and 4. Item number 2 and 4
হ্যাঁ তোদের জন্যই তো বলছি আমরা তো টাইম পাস
This is a specially fixed matter for argument on behalf of the state authority. Full stop. Learned Advocate General. Learned Advocate General was engaged to argue this matter on behalf of the state. An accommodation is sought for on behalf of the state authority. Let the matter peremptorily fixed on 25th of August 2025 at 2 p.m. as a specially fixed matter on top.
ছয়টা আমরা 7টা ওরা করছে
এটা হবে item number 4.
বলছে তুমি 6টা কি করে
As a second matter. Item number 4 হবে
7টার প্রথম দিন হলো
special fixed matter. As a second. Monday, 2 matters. Item number 2 would be the top and 4 would be the second.
Another indulgence. Item number 6 also.
Item number 6.
6 and 7 are same. 7 already concluded.
7 lordship, Mr.
Because Sonal Sinha is already concluded. But so far this matter is concerned, they have argued, started the argument, could not finish on that day because they told that one or two judgments shall be placed.
Right. So
is that I am hearing both the matters together, 6 and 7.
in our part of the argument আমরা ওদিন কি করব মানে আমাদের
আরে ভাই দাঁড়াও না
So Ms. Sonal Sinha
they almost concluded.
You have not concluded.
We have not concluded. We are taking the point of the maintainability that since the adequate alternative remedy is there, the petitioner should or avail the remedy. This judgment, this is the principal argument we are forwarding. Now we have not concluded our argument. Now what I'm deciding your lordship.
Let 7 be concluded.
7 be concluded. 6 I will do it on the next.
And in 7 means Sinha did not take the point of maintainability.
Yes.
Only merit she argued. So 7 may be concluded and কবে রাখবে
সামনে সোমবার রাখো Monday.
I have fixed another 3 matters.
I understand, Millard. This I just I've been told Miss Sinha is on legs on the another court, Millard. She has requested me to make a request to your lordship or not today. Make it not today.
This matter 7.
7. Just
they have concluded submission.
I don't know.
She told me that I can continue and I can conclude my
Reply.
submission. That was not
reply.
Whatever, maybe I will fix the matter
6
on
I
Monday
will do.
also.
Yes.
6 and 7 I will fix the matter Monday also.
Very.
This matter to hearing and may be concluded, but you will also be placed both the matter on that day.
Correct. Yes.
May I take your lordship, please, Millard?
But kindly take up the report affirmed by the Torun Kumar Mondol on behalf of the state, affirmed on 2nd of April. There are 2 reports. One is the report, another is the supplementary affidavit.
Exception to the report, exception to the by Torun Kumar Mondo.
আমাদের But before that, you will have to kindly take up my lord supplementary affidavit.
Supplementary affidavit.
Yes, filed by the petitioner, affirmed on 1st April 2025. There are other supplementary affidavit, need not go through the others. 1st April 2025, affirmed by Muktipada Kundu.
1st April.
My lord. Have you got it? But kindly come to page 7. Page 7 is the affirmed, page 8. Well, during pendency of the writ petition has been filed in the month of November, 8th November 2024. Instead of supplying or replacement of the 20 metric ton of rice, well, this rescind order has been passed after initiating a proceedings on 10th of March 2025 during pendency. On the one hand, they were paying for time for filing affidavits, and on the other hand, this order has been issued. As per order dated so and so, you are directed to submit the fine of rupees 2,76,000 so and so as imposed within 1 month from the date of receipt of the so and so. True core and 76 lakhs. The rescind order is at page 9.
Fine imposed during the continuation of the
Pendency
writ petition.
on the one hand, paying for adjournment to file affidavit, and other hand, this order has been issued, but this has not been given effect to since the matter is pending. And the rescind order is the next page. On the ground that shortage, our specific case is that if you lordship kindly take note of that the shortage which has been fined 3 times of the market price, if it is calculated this way, that would be seen my lord 20 metric ton of rice price they have collected from me. And so far the other matter is concerned 30 metric ton of rice. Admitted position. Now your lordship kindly take up their supplementary affidavit report. This has been heard stringently. This has been affirmed on 2nd of April 2025. Report in the form of affidavit.
Torun Kumar Mondol.
My lord, my lord. On 2nd of April at page 8, it will appear affirmation date.
Yes.
Now, your lordship kindly come to page 10. The case sought to be made out by relying on this paper documents that on 28th of February 2023, an inquiry has been conducted and it was found that there was no shortage, no excess rice.
Yes.
Have your lordship ever gone through that not a single kg bags have they found? All 0, 0, 0, 0, 0. There is no residual stock, and according to them, physical verification found nothing wrong. Entire goods are right, so there was no shortage. Kindly come to my lord. Para 7, page 5, how they have dealt with this document. This is Art 2, para 7, page 5.
Yes.
Their statement is that subsequently on 28th of February 2023, the stock of the petitioner was verified by the officials of the Food and Supplies Department in presence of Nimai Chandra Kundu, partner Messrs. Shaktipada Kundu, when no deficit in the stock of rice could be detected in the accounts of the petitioner. Hence, it is not understood as to how the petitioner had given the said 20 metric ton rice to the Arambagh municipality when his stocks were intact. According to them, on 2015, I have given the rice. This shortage will continue. And since they have conducted an inquiry and found that there are zero balance in all items, so these goods I have never been given to the municipality. Well, I have never passed through a report of the inquiring personnel which says there are not a single gram of rice or other articles is there. Every time, my lord, your lordship knows the adjustment is being made after delivery of the goods, after distribution to the dealers. Some residual stocks will be there, and thereafter some goods will be given for adjustment.
Yes.
And it cannot be happen that a single quota of ration articles is not lying in the godown. Well, these are my case.
That is quite impossible, you say.
Quite impossible. It cannot be. At least a broken bag should be there.
A distributor is supplying the ration articles
Yes.
to the dealers.
Dealers.
So dealer say distributor have 100 quintals of rice.
Yes.
He distributed to the dealers 80 quintals.
Yes.
So the remaining 20 quintals.
Absolutely. Your lordship knows whenever a dealer or distributor is suspended, it is being tagged with the other dealer or distributor.
Yes.
And the residual stock, your lordship kindly say, should be transferred to that. Because there are stock should be there. Stock should, it cannot be happen that after distribution, entire goods have been
Yes.
delivered.
Stock
So
cannot
say
be-
short to get out the case only by this way. This is my first point. Second question, your lordship kindly consider. Subdivisional controller in writing requested the district controller that the executive officer receive the goods, you should replenishment. No steps have been taken against the subdivisional controller. Why you are writing this letter? Because so far the municipality case is concerned, this letter has been addressed to the subdivisional controller. And subdivisional controller instructed me to deliver the goods at emergent basis. Question of obtaining any approval from the district controller does not arise at all. Your lordship knows, my lord, so far the allotment order is concerned, that these are being issued by the subdivisional controllers, not the district controllers. His duty is to issue the allotment orders. When he asked me that this is the situation, at emergent basis, you have to deliver this to the municipality, I cannot deny the same. The district controller says in the affidavit that I have not given permission. That's the only case made out. So entire fine in respect of both the cases is the quantity of goods which I have delivered to the municipality. So far the item 7 is concerned, and so far the other case is concerned 30 metric ton to the panchayats. All acknowledgements are there. In both the cases, separate letter has been issued by the subdivisional controller. Please replenishment the goods. These goods has duly been delivered with acknowledgement. But these are my case. So far the 7 is concerned.
Okay.
And the point which have been taken regarding maintainability, I have not challenged the punishment order. My case is that if you replenishment these goods, I can deliver the same and there will be no shortage in any of the cases. So my challenge is not the punishment orders. This has been issued subsequent to filing of my writ petition. Mr. Sengupta's argument is that there is a provision for appeal. But how can I file an appeal against the replenishment order? I am praying for return back of my goods. There is no such provision. They are going that in supplemented affidavit, I have since annexed a punishment order which is unnatural. I am not. You will also kindly see my prayer in the writ petition. Your lordship has rightly pointed out on last occasion.
Mr. Sir, this issue
Yes,
heard on Monday. That will be better.
my lord. Almost I have concluded so far.
I made it part heard only.
Yes.
As Miss Sinha is not there, I made it part heard. Your argument only on that point.
Only on that point.
Very good.
And my prayer is also that there is no prayer to quash the order of fine.
Argument on behalf of the petitioner on reply, heard in part. Let the matter appear in the list on 25th of August 2025 at 2 p.m. Let the matter appear in the list. It is 6 order. Let the matter appear in the list on 25th of August 2025 at 2 p.m.
Both the matters.
Both the matters.
I'm get close. Hard in part.
Both the matters, sir.
I'm get close.
Hard in part. I have fixed the matter on Monday.
Acha. He has completed his part?
Already made part. Already made part. Reply part. Mr. Sahara will again argue on that.
2 minutes. আমি না বললেও হয় almost বলা হয়ে গেছে সেভি করে দেবে এটা
করিয়ে দিন আমি তো
I have completed my this is my submission only because my learned friend has not taken the point of maintainability.
and with respect to I don't know dekho Lordship, let it be on Monday. If I will see, I will watch the live stream. I will see if I have to convert anything or not. And though I have missed the good part.
Monday.
Okay. Call the list. Number
23. Oh, no.
20 তো হয়ে গেছে
20 opposition file ko hai 20 ke running
No, 23. আমি ওই যে লাস্ট পাঁচশো সময় চলে এসেছে
opposition দেওয়া ছিল ভুলিলো ভাই আসবে
The morning 20 has been called on.
Yes, 20
But possibly, my lord, Mr. Mukhopadhyay appeared, my lord, he has prepared the opposition. He wanted to submit the opposition. We'll submit it on the next time.
No, call 22 first. 21 has already passed.
21 probably your lordship was taking up while your lordship was rising.
21.
Yes, my lord.
21,
My
na?
lord, 20. My lord, I tender my apology, my lord. I could not appear when the matter was called on. My lord, I have gathered that my learned senior friend, Mr. Sengupta, was arguing on this point that the present writ petition is probably not maintainable, as there were no documents to suggest that there was any veracity with regard to selection of the private respondents to the having received the license.
Yes.
My lord, only thing, my lord, apart from that, my lord, kindly recall, I have made a humble submission before my lord that there is a distinction between the pleadings in the plaint and the pleadings in the writ petition. In the plaint, there is no requirement for evidence part is concerned. Only statement ever.
With regard to
regard to the 226, my lord, some prima facie evidence, whatever their contention, they are saying this and that. My lord, there should be a prima facie satisfaction before entertaining the writ petition. My lord, kindly consider otherwise, my lord, this will open the floodgate, and my lord, again, my lord, consideration of no help. My lord, kindly consider one thing. Let there be a judgment on this, my lord. Up to that is up to my lord, of course, my lord. But my lord, unless they satisfy, because my lord, prima facie, they have to satisfy their contention that the private respondents in whose favor the license was granted, because he did not meet the credentials which he has alleged. Because I could have understood, yes, this is the agricultural land he has annexed. This is the area of the godown is such and such, which he has complied with, he did not comply with. Well, that means at least one. Well, a mere statement in the writ petition will not do. Well, there should be a judgment of this already. And they participated in the selection process.
Yes. My lord, to this, my lord, may I humbly reply to my learned senior friends' submissions before your lordships. That, my lord, the fact remains that the writ petitioner was a participant. The fact also remains that the writ petitioner is found to be one of the eligiblest candidate. Why I say this? I have appended the documents of the writ petitioner, which suggests that he would have been a very much eligible candidate had it been the case that the private respondent would not have been given the license. Why I say this, my lord? As of today, my lord, the writ petitioner is in dark with regard to his status out and the outcome of the selection process. There is, I suppose my learned senior friend will agree with me, my lord, there is, my lord, no result which is being uploaded as of today with regard to this vacancy, that the writ petitioner could have understood that yes, according to this is parameters, the writ petitioner does not come within the scope and ambit of having challenged even. When the writ petitioner has participated, yes, I do undertake. And at the same time, the writ petitioner is, my lord, probably in my humble submission, I may say that it was the duty of the authorities also, when I had made the representation, to at least reply that this is your status and this is the comparative status of the private respondents, who is much more in a higher pedestal than you. Then I would have been out of court, my lord. I would have not ventured to come before the court. Because everything is in dark, as my learned senior friend suggests that I have not put up any evidence, as well as it is upon the state respondent. State is a welfare state. They could have also written to me in one line that these are parameters under which you do not come. In several other cases before your lordships, my lord, the state comes with a report of comparative study and gives a chart before your lordships that this is the rank which you are in. But I have made this allegation. My lord, kindly takes, my lord, page 37, inquiry was held. Page 38, I was called in for the interview. And page 39 is my representation, 30th of June. Today we are in end of August, more or less.
Let them at least reply to this and give me a status as to as with regard to my pedestal, where I stand in the vacancy. I have complied with each and every formalities of them.
No, that is not the issue. You just read your representation.
Yes, my lord.
You read your
But I have gone through, my lord. I
page 40.
yes, my lord, 40 paragraph 4.
Paragraph
When
4.
I have a very, my lord,
Situated in agriculture land.
yes.
So where is the document?
I say this, my lord. The writ petitioner may be bereft of document, as well as the fact that the writ petitioner may not have a case prima facie, that my learned senior friend is arguing. But at the same time, the writ petitioner should know his fate about the vacancy. At least.
Then your representation should be displayed.
But page 39.
Representation should be relegated to the authority.
Lord, kindly do this, my lord.
Yes.
No, apart from that, my lord, sorry, the scope of judicial review, my lord, knows that unless there is a prima facie case, judicial review in a 226 matter is very much limited. Not that my lord is powerless. Yes, of course, if the prima facie shows some documents, my lord, again, because why I am submitting this humble submission before because it will open the participation.
I understand your submission.
Yes.
I understand your submission.
Yes, yes.
Please take
May I file my affidavits of service, including the mentioning notice, my lord, they have received.
Affidavit of service filed on behalf of the petitioner be taken on account. Petitioner applied for license in terms of vacancy notification dated
Page 27.
May 2024, issued by SCFS Purulia Sodor. After the application of the petitioner was received online, his proposed shopcom go down was inspected by the concerned authority. It is the thereafter he was called on a personal interview. He appeared there. Thereafter he came to know that the respondent authority has selected the private respondent. It is the firm contention of the petitioner that the private respondent has no sufficient go down to run the license according to the vacancy notification. It is the further contention of the petitioner that the private respondent has constructed go down over an agricultural land. He made a detailed representation to the authority concerned on 13th of June 2025, but his representation was not considered, hence this date. Learned counsel appearing on behalf of the state authority submits that the petitioner has not filed any document to apprise this court regarding the prima facie of his grievances. He further submits that the instant writ petition is not maintainable. The petitioner, being an unsuccessful candidate, cannot challenge the entire selection process. Having heard the learned counsel for the parties, it appears to me that the petitioner is one of the applicant who filed his application by placing necessary fees, by giving necessary fees, and his proposed shopcom go down was inspected. He was called on a personal interview. Thereafter, his candidature was rejected. He made a detailed representation. It appears that the licensing authority SCF is concerned, though have received the representation but not replied the representation. The present petitioner, being a candidate of the said selection process, must give in a reasonable knowledge regarding the fate of his candidature. Under the above observation, I think it necessary to relegate the representation to the subdivisional controller concerned so that the grievances of the petitioner may be redressed. Under the above observation, the instant writ petition is disposed of with a direction to the subdivision controller food and supply Purulia Sodor, being respondent number 4 of the instant writ petition, to dispose of the representation of the petitioner dated 30th of June 2025 within 6 weeks from the date of receiving of the copy of this order, by giving a reasonable opportunity of being heard to the petition. The decision of the authority shall be communicated to the petitioner within 2 weeks thereafter. I make it clear that this court has not entered into the merit of this matter. The subdivision controller concerned shall dispose of the representation according to law without being influenced by any observation of this court. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted.
Obliged.
Disposed.
Obliged, my lord.
Next.
Twenty-two.
Pursuant to your lordship's direction, my lord, they have filed a report. My lord, I have also found an exception to that report. Report to Devas is one. Exceptional copy page. Exceptional copy to teach.
Yes.
Matter relates to selection of APS dealer. I have challenged the selection of the private respondent, also elimination of the petitioners from the competition. They have filed a report. From the report, itself it appears that while submitting the online application, the selected candidates did not submit some necessary documents. If that we show, his application should be rejected at the time of initial stage without granting any opportunity. Now, my lord, kindly see the lordship got the report filed by the state authorities, my lord.
Yes.
My lord, kindly. The difficulty is, the report is not paginated, my lord. That's why. Lordship, kindly see the middle portion, the folded pages, my lord. Kindly.
You are appearing on behalf of the state.
Yes, my lord. I am led by Mr. Swapun Banerjee, learned AGP. He is in courtroom 37.
Shall I start this matter today?
My lord, kindly fixes it tomorrow, my lord.
Tomorrow again. Let it come on tomorrow. Without...
I have no objection.
Okay, please take down. Exception on behalf of the petitioner to the report. Exception on behalf of the petitioners to the report filed by the state respondents be taken on record. Let the matter appear 27th of August 2025 under the same heading. 27th of August.
My lord. Take care.
After the petitions, there is no private respondent. This is the affidavit of service. Other of the petition. But I'm finding a supplementary affidavit handing over copy. Two documents I although mentioned in the rectification could not annexed.
আমি ওটা পয়েন্ট করতে যাচ্ছিলাম
I have written that the copy is annexed, but it has not been annexed. So submit. But Kamal Krishna Mondal, since this was the father of the petitioner, holding manner fair voice shop license. But he had three sons: Nobin Mondal, petitioner of your lordship, Shomir Mondal, and Shamol Mondal.
আপনি আজকে সকালে আসলেন না না তো আমি এই কি বললাম তো রেডি
Kamal Krishna Mondal was the original pillar. After his death, three sons: Nobin Mondal, Shomir Mondal, Shamol Mondal.
Nobin, Shomir, Shamol.
But kindly come to page 65. This is the death certificate of the deceased dealer at page 65.
Yes.
The father died on 29th of November 2011. Middle portion, if you will also kindly see the name, then male, then 29th November 2011, not so legible. Kamal Krishna Mondal. After his death, three sons jointly approached the subdivisional controller for granting license as partnership firm. That will appear from page 66 within 60 days on 13th of December 2012, 13th of January 2012. This is within 60 days. Died on 29th November. Time is fixed 60 days up to 28th of February. Before that, on 13th of February, 13th of January, they have applied for. But no steps have been taken so far this application is concerned. Page 68, the prescribed application submitted by three sons. Appear from serial number 7, Shomir, Shamol, Nobin.
Page
68, prescribed application, duly filled in prescribed application, serial number 7.
Yes.
The next page, all the documents, no steps have been taken. Representation made, even then no steps. Then you should kindly turn to page 73. Petitioner have been told that at that material point of time, there was no provision to change the status of the business to grant compulsory appointment from ownership to partnership.
Yes.
Then petitioner applied for Nobin Mondal. Kindly turn to page 73. Is the application 9th of February 2017, addressing to the subdivisional controller with a copy to the director and district controller. The acknowledgement is at 10th of February 2017. Well, 4 years, no steps have been taken. Then kindly turn to page, my lord. Next page. On 13th of July 2021, petitioner has been instructed to submit the following documents numbering 15.
Yes.
Petitioner submitted all those documents. Kindly turn the page. It starts from duly filled in prescribed application, page, my lord, 75. All the documents, land document, medical certificate, everything, and NOC from one of the brother. If you will also kindly turn the page, page 81. Shomir Mondal, one of the brother, issued NOC in favor of Nobin Mondal, who has applied for a petition of your lordship. The first line says Shomir Mondal. I have no objection.
Yes.
Shamal Daini.
Then in the meantime, during pendency of the application, 2 vacancies has been notified on page 83, carteling the total ration cards 50-50. 2 vacancies has been declared, page 82, and another is page 86.
Yes.
Well, now I will also kindly take up the supplementary evidence. I have again stated in my repetition due to inadvertence that has not been announced. Kindly turn to page 30. I moved before this honorable court. Since my application was pending, without considering the same, you cannot declare a vacancy.
We cannot.
But the order in portion, page 30, 9th December 2024, this court passed an order. Kindly turn to page 32. the operative portion. Last but one paragraph, considering the entire facts and circumstances of the case, also considering unexplained silence of the respondent authority, I find urgency to pass an interim order. The vacancy notification of the authority vide memo dated so-and-so and memo dated so-and-so, respectively, both dated 15th May 2024, is state delay period of 10 weeks. Well, time to time, this interim order has been extended.
23.
Then your lordship kindly turn to page, a report has been filed. It will appear from page 5 of my supplementary affidavit, which I also could not annex in my petition, although stated. Page 5, your lordship, kindly turn up.
Affidavit in opposition.
Affidavit in opposition, sorry.
Which is annexed in supplementary affidavit, na?
Supplementary affidavit. Well, this is page 5. Your lordship, kindly come to page 19. Running page 19.
Yes.
And hearing has been provided, opportunity of hearing that will appear from 19. Hearing has been provided by the subdivisional controller. Then an order has been passed by the deputy director. If you have to kindly turn the page, page 20. Deputy director license intimated
Yes.
to the district controller rejection of the application of Sri Nobin Mondal, petitioner before lordship for engagement as Fapai shop dealer on compassionate ground. Reference is memo dated 22nd August 2022. With reference to the above, the undersigned is to inform him that the Director District Distribution, Procurement and Supply has rejected the application of Sri Nobin Mondal for engagement as a shop dealer in place of his deceased father, late Kamalkanti Mondal, as the applicant has failed to produce no objection from all other family members. I have submitted 3 sons. One son has been given, another son has not been given NOC of the deceased dealer. Mother has died long back. As required under the clause 20, Roman 5 of the West Bengal Public Distribution System Control Act 2013. He is therefore requested to take necessary action towards declaration of resultant vacancy due to death of Kamal Krishna Mondal as dealer as per norms. Now you will also kindly come to page 12.
Page 12.
My lord. Of supplementary, yes. Well, they have not stated anywhere in the opposition also that this document has ever been intimated to me. Only from the affidavit, they have disclosed this document. This has never been served upon us. The order dated 20th February 2023. Now you will also kindly come read 2 or 3 paragraphs of my supplementary affidavit, page 12 first. This is the report, part and parcel of the affidavit. Sorry. Kindly come to Roman 6.
Roman 6.
Roman 6. It is to be specifically mentioned that the petitioner, along with his brother, were summoned twice by the subdivision of Food and Supplies Kolani Bhai Memo dated so-and-so and Bhai Memo dated so-and-so. However, one of the legal heirs, being the brother of the petitioner, namely Shamol Kumar Mondal, did not appear. Kindly take note of my word. Notice has been issued upon the brothers in regard to the NOC. I appeared, other brother appeared, but so far Shamol is concerned, he never appeared. Did not appear in both the hearings, which is an essential requirement in order to record this consent. Hence, the consent of no objection of one of the legal heirs could not be recorded. A copy of memo dated so-and-so is annexed to. Therefore, the petitioner was not able to produce the NOC certificate of all family members excluded before the first class magistrate, record under clause so-and-so and appear so-and-so. Then let us kindly come to page 72 of my petition. Well, this is a cash memo in the name of Shamal Kumar Mondal, who is the carrying cum storing agent of mid-day meal rice. The brother who has not issued NOC in my favor, he is solvent, he is running a business, he has the license issued by the same department, carrying and storing agent of mid-day meal rice. I am sorry, my lord, not the same department, Panchayat department, but very much related to the Food and Supplies department. He is an agent of carrying and storing agent. Today I am submitting before your lordship in terms of the division bench judgment, Guru Padadas, that it is required to conduct an inquiry in the attack given by the subdivisional controller to see whether the person concerned who has not given NOC, kindly come to my lord, para 14, page 13,
Yes.
is a eligible candidate or not. If not, there is no requirement to obtain an NOC from the person concerned who has the influential person. Kindly read my lord, page 13, paragraph 14. Now the most important question is what is the meaning of no objection from other family members. Family members have been defined. Madam, আপনার কাছে তো কপি নেই। আর কপি আছে?
Judgment. Judgment.
Defined in clause 2, aim of the controller of so and so. Family members means spouse, dependent parents, dependent sons and daughters for the purpose of considering engagement of dealers, distributors on compulsory ground. The most important word in the definition is the word dependent. If any of the family member was not dependent on the deceased on the date of death, his no objection is not necessary for consideration of the issuance of license in favor of any of the legal heir who has applied in Form C along with Annexure 1 of the Control Order 2030. If any of the sons or daughters who are dependents, they are required to file no objection. If we read paragraph 2 of clause Roman 6 of clause 20 in conjunction with clause 2M, it would be clear that only sons and daughters who were dependent on the deceased on the date of death are required to file no objection and not all family members. The concern of the authority holding inquiry, therefore, it is to find out whether the person who has not filed affidavit was dependent on the deceased on the date of death or he was living separate or independent from the deceased. If the answer is to the effect that he is independent and has got sufficient means of subsistence, no affidavit by the legal heir need to file, and without his affidavit, also the application of a legal heir can be considered and allowed. Next paragraph. It is settled law that negative facts cannot be proved. Therefore, if any of the legal heir files an affidavit to the effect that he was dependent on the father on the date of his death and he is eligible to be restored with the benefit contained in clause 20 Roman 6 of the 2013 control order and other family members, namely such and such are independent. The simple exercise subdivisional controller food and supplies has to do is to issue notice to other family members and hold an inquiry asking them to prove the affirmative that they were also dependent on the deceased on the date of his death. But pausing for a moment. I have shown to your lordship from their document that twice notice has been issued in favor of the person who was not giving the NOC, and both time he refused to participate in the hearing. The division bench says that he is not an eligible candidate, and in that case, no NOC is required. Then, next paragraph. Further, is found that any of the legal heirs was not dependent on the deceased on the date of death, and he has got sufficient means of subsistence, cannot insist upon the no objection affidavit by him. If we go any other interpretation, the meaning of paragraph 2 of subclause Roman 6 of clause 20 read with clause 2 paragraph M of 2013 control order, that will defeat the purpose of benevolent scheme of the compulsory engagement in as much as any person who is independent for the ex-dealer during his lifetime can also come forward to frustrate the chance of the otherwise eligible legal heirs to get a license on death of his father who was in ex-dealer by not filing NOC. Though such an action may be owing to sibling rivalry, meaningless or preferential, therefore, when both the previous are read in conjunction, both the points are read in conjunction, the clear meaning that come out is aforesaid. Therefore, in our material consideration, that the application of the applicant be repossessed, accessed, keeping in mind whether respondent number 6 who was not in objection was dependent on the deceased father Raspberry on the date of his death, or such view is also supported by the pattern of cases which decides that the so and so. That very decision of the scheme of compulsory appointment is dependence. The very purpose of any of such scheme is to be provide succor to such dependence, so the really the engagement to dependence or dependent defeat the very purpose of such policy scheme. We find that in clause 2 Roman 6 2013 control order, there is no time limit prescribed for the authorities to act on the application filed under the said approval and also come on to across the course where claims are kept pending for years. We therefore issuing our penalty power to Article 22 of Constitution of India, entitled the state government to comply with the following circumstances. Every application should be disposed of within 6 months from the date of filing of the formal application under paragraph C of the annexure so-and-so control order. Then, Roman 2. If there is any defeat in the application be intimated to rectify the defeat within 1 month from the date of his filing of this such defeat. He will rectify by the applicant within 15 days of such application. Third is very important. If the application cannot be proceeded by the outer time limit of 6 months, outlined for any reason, temporary license should be issued in favor of the applicant, subject to the condition that such license shall be subject to the outcome of the inquiry. If more than one application has been received from more than one legal year, the application of the submitted his application who submitted his application first should be issued with the temporary license. If no application be kept pending beyond 1 year. So my case is today, my lord, there was no inquiry conducted. My specific case is that one of the legal lawyer who is not willing to give NOC has called for hearing in twice. He never approached. He never participated. He did not make any application also. So straightway division bench judgment covered my case. There should be a direction upon the respondent authorities to grant license to me, because out of 3 legal layers or the family members, I have applied for another brother has already given me NOC. From their document it appears twice this gentleman who has not been given NOC has been called for. He never approached. I have also shown to your lordship from my repetition that he is a carrying cum storing agent of the mid-day meal rice. Only my lord dependent person is entitled to make application or record to submit NOC. And in the meantime, my lord proposal has been given for declaration of fresh vacancy that I have also shown to your lordship in the order impugn. These are my case.
So what is your prayer here?
Prayer A is to grant license to me. Kindly come to prayer page. Just I'm sure. Editing the nature of mandamus, commanding the respondent, each one of them the serving systems are assigned to resign, cancel, or withdraw and or set aside the order rejection bearing number so dated 22nd February 2023, issued by the director license, director BTPS so and so.
2nd February.
Yes, 2nd February, that is the rejection order, which has never been handed over to me, only annexed in the affidavit of petition. And second paragraph is also set aside and grant license. No, vacancy decline notice. C is the prayer, my lord. To grant the prayer shop license at page 43, prayer C. And I have also paid for an stay order if your lordship directs them to file a report, not to issue any vacancy as per the proposal of the directorate. That will appear from my lord page 45 bottom, prayer G. But altogether, I was enjoying an interim order, staying the operation of the vacancy decline notice at page 82 and 86. But I have withdrawn my writ petition after getting this affidavit in opposition. If your lordship kindly come to page 94 of my writ petition. The moment I have been intimated that my prayer has been rejected, I withdrawn my writ petition with liberty to file afresh with the self-same cause of action, which will appear from page 94. But today there is no interim order since the writ petition has been withdrawn. But altogether there was an interim order staying the operation of the vacancy decline 2 notices. Page 82 and 86 of my writ petition. Lordship will appear from page 95, liberty to file afresh. And if interim order, if any, passed in the court is vacated. The lordship sought for an report. After conducting inquiry, they may submit it. In the meantime, my lord, vacancy decline notice, which was stayed for years together, can be stayed.
Where is the order of injunction passed by this?
Order of rejection.
Order of injunction?
Order of injunction in the supplementary affidavit I have annexed.
in the supplementary affidavit, Your Lordship. It is appearing at page 30.
Okay, 30.
And operative,
17.
my lord, absolutely. My operative
9th
portion,
of December.
9th of December.
and operative portion page 32. Last but one paragraph. These are the two mistakes. It should have been annexed in the repetition.
So during that period, the order has already been passed.
Yes.
When I passed the order,
Order has been passed, rejection, but that has not been handed over to us.
That was done in the year 2023 itself. Yes. And Lordship's order, one more order I can see. This vacancy came in way back on the 15th of May 2024. Before Lordship's order dated 9/12/2024. That order was already in existence, 23 order.
But never it has been communicated. This is not their case.
to me.
Lordship, that I will have to take
Yes,
instructions.
that was not intimated.
That I will
No,
have
and not in the affidavit they have stated anywhere that this has been served upon us. This is not their case also.
That does not tantamount to be not being served at all. Let me come back with this instruction. And moreover, Your Lordship, I will make one humble submission that Shyamal Mandal is a necessary party since he is the brother of Naveen Mandal and he is the only family member who is not agreeing to give the NOC. So he should be made a necessary party. One, why on basis of my submission is because engagement on compassionate grounds, what does it say? If Lordship knows better than me, kindly sees 26. Kindly sees once. Bolchi.
Yes.
6. Engagement on compassionate grounds. The whole case is based in case of death or in case of incapacitation on medical ground, subject to satisfaction of the authority of any existing dealer, prayer of any of the family members of the deceased / incapacitated dealer having no regular means of income may be considered on compassionate ground. My learned friend has tried to make out a case on this ground. If such prayer along with formal application in Form C2 along with Annexure 1 with requisite fee as prescribed in Schedule A, corroborative documents as per checklist and no objection from other family member in the form of an affidavit to be sworn before a magistrate in Annexure 2 is submitted. Provided that in case of death of a licensee, such prayer is submitted within 90 days from the date of death of the licensee. Provided further that the licensing authority may, on just and sufficient grounds shown by the applicant and for the reasons to be recorded in writing, accept such application up to 120 days from the date of death of the licensee. Provided further that no objection is required if the applicant be the spouse of the deceased licensee or if the licensee, because of his/her being incapacitated, infirm, has opts the name of the applicant. What I'm trying to submit before your lordship is merely by saying that he is doing exceptionally well in Gujarat and he is supplying midday meal in Kalyani does not tantamount to his being in a very good state. He should come before the court and say that he is not willing to give the NOC, whether he's interested in giving the NOC or not, so that we have no objection. We will see what we can do after that. Just by mere submission that he is not giving the NOC, and I just consider him that he is having hefty amount of resources to have a very good living, that nowhere from the writ petition it can be reflected. So I will request my learned friend to make Shyamal Mandal, the brother of the Naveen Mandal, a necessary party. He is a very, very important party in this writ. ঠিক আছে ও that's a major issue. দেখছি
That's all.
এই মুহূর্তে তো that's all. 2023. My only query that has fallen from your lordship, why the department could not communicate this order, that I will come. Give me just 1 day's accommodation, that I will come with. Because in the I will not deny the fact that in the supplementary affidavit, the affidavit of opposition that has been annexed, the affirming date is 2025. Being an officer of the court, I will come clear on this. These are my humble submissions, and lordship's order staying this 15/5/2024 vacancies This is much prior. That is 9/12/2024. If Lordship sees once the order which
9th
was
of December.
9th of December, and this is 15/5/2024.
Yes,
Yes, and 2023, the order of rejection has been passed.
but it was not intimated to this court while
Yes,
passing the
that,
order.
that is what I'm also in a
Yes, why not intimated to this?
so that is why I want,
It has already been passed.
yes, that is why I want to seek an explanation for this. Only this is the hurdle that I am facing. Otherwise, rest of the prayers I have made before your lordship. One is that Shamal Mandal should be made a necessary party. Just going on to say that this is coming from as a submission from the bar that he does not need any money. He is very well. He is doing extremely well. So my one prayer will be this, and second is the clarification which I want to come up with.
My submission would be, my entire case based upon my lord, the judgment of the division bench. In that case also, my lord, the one of the brother was not made party. Court directed the subdivisional controller to conduct an inquiry. And in the meantime, since he is the only applicant, provisional license must be given to.
My humble question that is not humble, a question that, because we are learners, each day we get to learn something new. One question that is haunting me repeatedly is, what is the embargo in making him a party? Let him come and say he does not want to. Tomorrow again there will be a litigation on the same basis that I was not given any chance.
Such matter, such altercation between the brothers and the parties should be dealt with by the subdivisional court, not before this court. Okay, these are the issues to be settled by the subdivisional controller, the authority.
Yes, that I will not go into, but Lord,
There may have some disputes between
but
the
here
parties like that.
the prayer is to stay those notifications 2024, though they are enjoying an interim order which was passed by your lordship on 9/12/2024. That is still there.
Vacated. That was vacated letter.
और पूरे की मैं और पूरे की
It was vacated letter.
জানো না না vacate হয়ে গেল ওর পরে কি স্ট্যাটাসটা আছে তুমি জানো? That is what I'm trying to, what is the status after that, whether licenses have been issued, what has been done. I just want to have satisfaction, my queries with the department. License দেয় নাই, কিছুই হয়নি. That's what I've got to learn from my learned senior friend at this point of time, that no license
I can
has been
dispose of
issued.
this matter today or tomorrow. What do you want?
Lordship, if that is what is it, is in dispose of করে দিই।
দুদিনের ফিস নেবেন না একদিনের ফিস নেবেন?
আমি কোনো সময় ফিসের জন্য কাজ করি না।
Tomorrow?
You can, lordship may dispose it today also.
Today, okay. Right.
Now get closed.
Please take down. One Kamal Krishna Mondal was FPS dealer. He expired on 29th of November 2011. He had 3 sons, namely petitioner and other 2 sons, Samir and Sama. Full stop. 3 sons of the said deceased Emma dealer applied for license jointly under partnership. The said application was filed within the statutory period, but the application was not proceeded. However, it came to know to the sons through the department that the ownership license cannot be transferred in the name of partnership. Consequently, at the instruction of the authority, the present petitioner applied for license under individual capacity. on 30th of, sorry, on 9th of February 2017. There were a long silence from the department, and on 13th of July 2021, the department has directed the petitioner to submit certain documents. Accordingly, he submitted those documents. But the concerned authority has not taken any decision. Accordingly, however, has not taken any decision, but has issued two separate vacancy notification on 15th of May 2024 in respect of the same service area. Full stop. The petitioner approached this court with a writ petition number WPA 28189 of 2023, whereby this court with an order dated 9th of December 2024 has passed an interim order staying the operation of impugned vacancy notification dated 15th of May 2024. Full stop. By such order, this court also directed the respondent authority to furnish an affidavit in opposition. In terms of such direction, the respondent authority has submitted an affidavit in opposition on affirmed on 22nd day of April 2025. Full stop. Along with such affidavit, the respondent authority has placed the document whereby the prayer of the petitioner for engagement on compassionate ground was turned down by the concerned authority on 22nd of February 2023. The petitioner approached this court challenging the said vacancy, said impugned order dated 22nd of February 2023. Mr. Devbrata Sahara, learned senior counsel, appearing on behalf of the petitioner, submits that the respondent authority has passed the impugned order without following the provision laid down in the Control Order 2013. Further submits that this court, the division bench of this court in Chittaranjan Das, in Gurupur Das versus State of West Bengal, has categorically ordered how the issue of compassionate appointment should be decided by the authority. Sir, I further argued that before deciding the matter, the competent authority must conduct an inquiry regarding the fact whether regarding the fact who are the dependent upon the deceased dealer at the time of his death. At the time of his death. Mr. Sahara submits that the authority concerned has not followed the decision, followed the law laid down by the Honorable Division Bench in Gurupada Supra. Thus, the order passed by the concerned authority is liable to be set aside. Passed by the Honorable Division Bench in Gurupada Supra is required to be set aside. Ms. Sonal Sena, learned counsel appearing on behalf of the state, submits that deceased Kamal Kumar Das had 3 sons, namely Novin, Shomir, and Samol. Stop. Novin, within bracket petitioner, Shomir, and Samol. Novin is the petitioner herein, who submitted no objection of one of his brothers, Samir, but he failed to submit the no objection of one brother, Samol. Stop. Samol is one of the son of the deceased Emma dealer. Thus, he is a necessary party of the instant proceeding. Full stop. Instant proceeding. Ms. Sina further argued that the decision has already been obtained by the authority regarding the rejection of the prayer of the petitioner. Thus, at this juncture, there is no illegality. At this juncture, the instant writ petition challenging the said order passed in the year 2000. Passed in the year 2023 cannot be challenged. He further submits that the further submitted. Having heard the learned counsel for the parties, also considering the impugned order dated 22nd of February 2023, it appears that Director DDPS, Deputy Director License, Deputy Director License issued the memo to District Controller Food and Supply Nodia regarding rejection of application of the petitioner for engagement as a PS dealer on compassionate ground.
There has been rejected by the director, intimated by the judge.
Yes.
First line.
It has been intimated by the Deputy Director License that Director DDPS has rejected the application of the petitioner only on the ground that all other family, only on the ground that the petitioner stroke applicant has failed to produce no objection from all other family members of deceased dealer as required 20 within bracket 6 of the West Bengal Public Distribution System Maintenance and Control Order 2013. Full stop. This being the sole ground for rejection to appreciate the entire law in hand regarding the compassionate appointment under Control Order 2013, it is required to set out again, to set out the said provision enumerated under clause 20 within bracket Roman 6 of WBPDS within bracket M and C order 2013. এটা সেটঅপ করো Roman 6A Roman 6A এই বইটা পেজ করা আছে।
Okay.
The said issue, next paragraph, said issue of compassionate appointment was further deliberated by the division bench of this court in Gurupal Das versus State of West Bengal within bracket MAT 842 of 2022. In paragraph 14, 15 and 16. To 18, in paragraph 14 to 18 of the said judgment. The observation of Honorable Division Bench is required to be set out for the better appreciation of the law. Next paragraph. Peculiar fact suggests that erstwhile MR dealer Kamal Krishna Mondal expired on 29th of November 2011. Full stop. Within the very short period, that is within on 13th of January 2012, all the sons of such MR dealer approached the authority. Since then, concerned authority kept a long silence. Subsequently, the individual application of the petitioner was turned down by order dated 22nd of February 2023. Full stop. In paragraph 20, in paragraph 20, within bracket Roman 7, the Honorable Division Bench in Gurupal Das has observed that Roman 6, Roman 7, that within court, the SDC, FS should not conduct a roving inquiry to find the factum of dependency. It should be an administrative inquiry giving opportunity to interested family members to prove his stroke her case that he stroke she was dependent on the deceased on the date of his stroke her death. Full stop. If all the family members have filed no objection, inverted comma there are affidavit, no such inquiry is necessary. If one or more than one of the family members have not filed within bracket no objection affidavit, such inquiry be conducted in respect of their claim only. Full stop. The direction of the Honorable Division Bench, if clearly dissect, it would appear that it is the duty of the concerned authority to conduct a conduct an administrative inquiry by giving reasonable opportunity to the interested family members who can demonstrate their grievances. It suggests that while making such inquiry, the respondent authority, the concerned authority, shall issue notices to the all family members, and if they are interested, they must appear before the authority to ventilate their claim. Full stop. In absence of such administrative inquiry, any order passed by the authority appears to me dehors to the direction of the division bench. I also make it clear that the direction of Honorable Division Bench in Guru Pada Das makes it clear that it is not the duty of the applicant to collect all the no objection affidavit of the legal heirs of the deceased, but it is also a duty of the concerned department, concerned authority to conduct an inquiry, to fix up the dependency point of dependency. Under the above observation, the duty, the impugn order passed by the concerned impugn order passed by the respondent authority on 22nd February 2020 appears to me not in conformity with the directives of the division bench of this court. They have the concerned director DDPS has already imposed the liability upon the applicant to collect no objection affidavit from all family members, which appears to me not a good ground to reject the application of the present petition. Under the above observation, I find justification to set aside the impugn order passed by the concerned DDPS on 22nd of intimated to concerned DDPS intimated by the Deputy Director License concerned on 22nd of February 2023. Under the above observation, the concerned DDPS being the respondent number 3. Now, under the above observation, let the matter be relegated to the Director DDPS, Food and Supply Department, Government of West Bengal.
3.
To rehear the petitioner.
Inquiry.
To the Director of DDPS. With a relegated to rehear the petitioner. To rehear the petitioner and conduct an re-inquiry in terms of the
an intimation to the necessary parties.
Decision.
Your Lordship, this will be through. The DDPS will do through SEFNS. DDPS.
So far the inquiry part is concerned, that may be done by the
SCF.
From Kolkata, it is not possible.
It's not possible. আমি বলে দিচ্ছি ওই respondent
In
number.
terms of the decision enumerated by the Honorable Division Bench.
6 আছে. 6.
Division Bench in Guru Pada Das versus State of West Bengal. The concerned SCFS shall conduct the inquiry in terms of the decision of the Division Bench and submit a report to the Director DDPS within 6 weeks. Within 6 weeks from the date of communication of this order.
Your Lordship, was the order of 22nd February.
Yes.
And in the meantime, not to take any steps so far the vacancies.
They have not taken any steps yet.
But
That is what he has said. I said I will come back with an answer. But he said he.
Status quo be maintained.
No, nothing will be maintained.
Prefer to keep silence on that point.
Oh, no, no, everything has to be afresh.
Okay, okay.
As your lordship.
Under the observer in the
Right, possible.
affidavit কিছু নেই ওটা করে দাও no I make it clear that this court has not entered the business matter.
But your lordship has quashed the order.
Yes.
बाप रे बाप, third time into live stream clear दिखा जाচ্ছে.
Yeah,
Grateful, your lordship.
This court has not entered the merit of this matter. The concerned DDPS shall take decision independently without being influenced by any observation. Without being influenced by any observation. Since no affidavit have been exchanged between the parties, the allegation made in the writ petition have been not admitted.
Yes.
DPM or keeping good.
Lordship, it has called 3 p.m. matter.
Yes.
Lordship, may
My-
other matters be
I do not know what is the 3 p.m. matter with the.
My lord, 3 p.m. matter, Mr. Banerjee says that he will take the entire time.
I'll take 20-25 minutes for that, and my last friend will be sufficient. Like
Advocates 20 minutes.
Few matter. It will take only 20 minutes more.
Lordship, we are
I have heard that matter entirely. I have heard that.
My lawyer friend has made his
I have
submission.
already heard that matter.
I was replying, my lord.
2 days I have heard the matter. Yes, give me the matter. Give it.
I am for the opposite party tenant, my lord. This, I am just recapitulating, my lord. This is a suit for eviction filed on several grounds, including the ground of building and rebuilding. The matter went up to the Honorable Supreme Court.
This is the book. Hey, boy, take another now.
So this matter was not arising out of a suit in the before the city civil court for eviction of tenant on several grounds, including building and rebuilding under the old Act, 1956 Act, under Section 13(1)(f). Matter went up to the Honorable Supreme Court. The Honorable Supreme Court granted a decree of building rebuilding. That was a decree. The trial court was to pass the formal decree. Supreme Court only passed the directions, allowed the eviction suit, tenants to vacate, landlord to rebuild the house, and the tenants to be put back in possession. After some time in the execution proceeding, because the decree was not drawn up correctly, after some time possession was handed over, although not within the time stipulated. Beyond that, handed over. After that, they completed the entire building, but only the portion where I was to be rehabilitated, that was not completed. Superstructure is there, entire building is complete, that portion is not complete. We filed an application in the execution case which was pending before the trial court, because the decree was a composite decree, both vacating and rehabilitation. We filed execution case. They challenged before this honorable court in a revision application, in which this honorable court held that yes, it is maintainable. They took the point of section 18 capital A. Court said that this is maintainable in terms of the Supreme Court's order, but you have to file your separate execution case, because the execution case which is pending at the instance of the landlord, in that you cannot file an application. Separate execution case filed. This is the background fact. Now he is challenging the entire proceeding, all the orders passed in the execution case, on the ground that the court does not, two grounds basically. One is that the court does not have jurisdiction to take up this execution case in view of the provision of section 18 capital A, which says that the controller has to take up an application. So he says it is without jurisdiction. And the other point is that he says this is in violation of the order of the Honorable Supreme Court. The order of the Supreme Court is law of the land, Article 141, 142. So although the coordinate bench has said that the execution proceeding is maintainable, it can be filed, that is in violation of the Supreme Court's order. So it is not maintainable. These are the two broad grounds that he has argued. On the last day, I have placed section 18A. My first point was that the point of jurisdiction doesn't arise at all, because I have placed before your lordship his previous application. One of the grounds taken by him is that the application is premature because the building is not yet complete. So the moment he says that the building is not complete, the provisions of the 56 Act, your lordship kindly once sees, my lord, it doesn't come into operation because it says specifically
After completion.
after completion. I'm grateful, my lord. So 18 capital A, before the rent controller will lie when he completes the building.
Yes.
Now, if he does a mischief by not completing the building and he admits before your lordship and before the executing court it is premature, not complete, then he cannot take the point of 18 capital A. This point was taken by me in the previous round also. Should I not have given it? 18 subsection 2 on completion.
Yes.
Now, in the application which was filed by him on the previous occasion of 2021, I placed this before your lordship on the last day, my lord. In paragraph 11, he says that it is premature because the food property is not complete. Kindly take some note. This is the previous round on which coordinate bench has rendered a judgment. Paragraph 11. Apart from this, in this round also, in the grounds, my lord, he has again stated that it is premature. So same stand he is maintaining. One of the petitions, he has filed several petitions. In CO 4296, ground 5, he has stated. So it was incomplete at that point of time, 2021. It is incomplete in this present case also. If your lordship, I am reading ground 5 of CO 4296 of 2024. This present batch of petitions, ground 5. For that, the learned court below erred in not considering the fact that the application filed by the opposite party is a premature application as the construction work has not yet been completed. So today also he is maintaining the stand that it is not complete. So the first minute objection of jurisdiction, I say that 18 capital A shall not be invoked because my execution was for what? For a direction upon them to complete the construction and give me possession.
Yes.
So this is the first hurdle, my lord. I humbly submit that he is now trying to, my lord, mislead the court to delay, my lord, the handing over of possession. And his stand is that, basic stand is that you have done a delay in handing over possession, so I will be also doing the same mischief. I will not hand over because I have handed over possession on 30th of August 2017. Lordship, kindly, my lord, marks this date, my lord. I'll give, my lord, 3 dates. First is, my lord, 5th of April 2007 is the order of the Honorable Supreme Court. 5th of April 2007.
Yes.
Then 23rd of November 2007, the City Civil Court passes the decree of vacating and then handing over, both. And 30th August, as per his own case, 30th August 2017, he obtained possession.
Yes.
So 2017, we are in 2025, and the time limit given was 3 months. So, my lord, these are the basic dates. Now, his second point is that the order of the Supreme Court has been violated. Supreme Court has directed 18A, so it has to go before the rent controller. I have shown, my lord, that as per statute, it will not go before the rent controller. Now, what is the direction of the Supreme Court? I'll place, my lord, the relevant portions to show that the Supreme Court has specifically directed the civil court, my lord, to pass all consequential orders to ensure that the tenant is put back in possession. And what the trial court is doing, executing court is doing today, my lord, it is absolutely in compliance of the order of the Honorable Supreme Court. Kindly, my lord, takes up the order of the Supreme Court. It starts from page 18. I will not trouble your lordship with, my lord, the entire thing. Kindly comes to, starts from 18. Just a second. Just a, kindly comes to page 37.
Yes.
37, paragraph 14. This, in my humble submission, is very important, my lord. Under section 18, capital A. Your lordship has got it, my lord. 18, capital A of the Act, the landlord, in a case of eviction under section 13(1)(f) of the Act, has the obligation to put the tenants back in possession of rooms in the reconstructed building.
You are reading?
Lord, I am reading from page 37. This is not CO 2467. Your lordship is looking at CO 2467. There's several revisional applications. 2467 I am placing, my lord.
Now, you are reading the page, inner page of
Internal page is, my lord.
inner page of judgment of Honorable
Inner
Apex
page.
Court.
Inner page, there's no 20. Inner page 20.
20, yes.
20, my lord. Paragraph 14. Under section 18 capital A of the Act, the landlord in a case of eviction under section 13(1)(f) of the Act has the obligation to put the tenants back in possession of rooms in the reconstructed building. That is an obligation attached to any decree for eviction that may be passed under section 13(1)(f) of the Act. Certainly, any attempt to defeat that obligation under section 18 capital A of the Act cannot be encouraged and should be put down with an iron hand. In other words, the landlord will be pinned down to his obligations under section 18A of the Act and would not be allowed to extricate himself from it or delay the performance of his obligation by resort to devious means. My specific submission is that, my lord, this is the devious means adopted by him, that he is not taking several rounds of litigation, even coming to the Honorable Court, taking the same point that the matter is not maintainable, although the High Court in the previous round has already clarified that. This is devious means, my lord, it has to be put down with iron hands as per the direction of the Supreme Court, which calls for, my lord, stringent directions against them. But that is different from saying that because of the right available to the tenant under 18A, an order of eviction under 13(1)(f) cannot be passed unless the building is about to fall down over the head of the occupant. Then, my lord, paragraph 15, the court, my lord, takes note of the areas occupied by various, I am not placing the entire paragraph, records, my lord, the areas occupied by the various tenants, who is occupying how much, 50% to be given to some, the rest, my lord, will get the entire area. And after that, my lord, kindly comes to page, inner page 23, my lord.
Yes.
23, my lord, I am reading from top. Interest of the tenants and will ensure that all the building laws are respected by the landlord while constructing. The modified plan will be produced by the landlord before the trial court so as to enable that court to pass formal decrees. Kindly mark, it says decrees, not decree. Decrees for eviction and consequential orders for the tenants being put back in possession in the reconstructed building as directed above in terms of section 18A. So the direction of the Supreme Court is very specific, my lord. Formal decrees are to be drawn up. One is for eviction, other is for consequential order of putting back in possession. And my lord, the court, I'll go to the decree now. Formal decrees. Then my lord, court gives the final direction in paragraph 16, page 24. We direct the trial court, third line. We direct the trial court to expeditiously pass decrees and consequential orders in terms of section 18A of the Act when moved in that behalf by the landlord. We direct the trial court to pass consequential decrees within 3 months of it being approached, either with the existing plan or the modified plan. This was the direction. Now, my lord, this has been interpreted as if the court has said that only under 18A the tenant can approach for getting possession, otherwise not, which is not the direction, because Supreme Court is very specific that the court will pass the decree and consequential order of restoration of possession. This is one. Now, kindly, my lord, allow me to place the decree which was passed. Page 58 of, my lord, this revision 2467, page 58.
Decree by Supreme Court.
Decree of the the decree passed by the City Civil Court in terms of the direction of the Supreme Court. Supreme Court directed the City Civil Court to pass the decree.
Yes.
Draw of the decree. Now the decree is passed, which is, my lord, in this petition it is page 59. Your lordship is looking at CO.
You proceed.
Your lordship has seen the decree, my lord?
Yes.
Yes. Now, kindly allow me, I'll just place the specific decree. At the schedule, it is ordered and decreed that, your lordship has got?
Yes.
That the suit be and the same is decreed on contest but without cost. Plaintiff do get a decree for eviction under section 13(1)(s) of the West Bengal Premises Tenancy Act. Sketch plan filed by the plaintiff on 13th do form part of the decree. Plaintiff is directed to obtain the sanction plan from the concerned authority, produce the same to the court and serve copy of the said sanction plan to the tenants, preferably within 3 months from the date of this order. Defendant is directed to vacate the premises within 1 month from the date of receipt of production of the sanction plan by the plaintiff. Plaintiff is directed to put back possession to the tenants in the reconstructed building within 1 year from the date of delivery of possession by the tenants to the plaintiff. In case of any neglect or failure to deliver possession of the suit shop room either by the tenants, defendants or by the landlord plaintiff, within the stipulated period as mentioned in the body of the judgment, possession will be delivered by putting the decree into execution on an application of either of the parties. So the decree is a composite decree, takes care of both, and says that if there is failure on any part of the any of the parties, they can put the decree into execution, either of the parties. Very specific and in terms of the Supreme Court's order. Now, there was delay on my part because the decree which was ultimately drawn up, the measurement was not correct. There was some dispute in the measurement. They filed the execution case. Ultimately, in execution, the matter came to this honorable court. This honorable court directed delivery of possession. Possession was delivered on 30th August 2017. So if that date be taken, my lord, within 3 months, within 1 year, they have to hand over possession. So on 30th August 2018, my lord, I have a right in terms of this decree to go for execution. I filed the application in the same execution proceeding. They challenged it before this honorable court. Now that order is not annexed. Kindly see not the order of this coordinate bench. This is an order, my lord, passed on 9th of January 2023 in CO 101 of 2021.
Yes.
Now, my lord, kindly come to page 10, paragraph 10 onwards of this order. I'll just place not 2-3 paragraphs. Paragraph 10 says, it appears that in spite of such specific observation made by the apex court, the petitioner herein has failed to assign any cogent reason as to why the suit premises could not be completed till now for giving back possession to the tenant, and under what circumstances possession of the suit premises could not be handed over to the tenant within the stipulated period mentioned in the decree, when admittedly he obtained possession of the suit premises for building and rebuilding purpose from the defendant opposite party herein on 26th April 2016, and admittedly from other tenants on 30th August 2017. On perusal of the judgment passed in title suit number 480 or 88, it appears that the court below has given direction to both the parties. Plaintiff was directed to obtain sanction plan and to produce the same before the court, serve copy of to the tenants preferably within 3 months, and the defendant was directed to vacate the suit premises within 1 month from the date of receipt of the sanction plan. And on the later part of the order, plaintiff was directed to put back the tenant in the reconstructed building within 1 year from the date of delivery of possession by the tenants to the plaintiff. Accordingly, in the same judgment and decree, the direction was made to both the plaintiff and to the defendant for compliance of their respective obligation and liabilities. In the last part of the order, it was further mentioned in case of any neglect or failure of delivery of possession of the shop room either by the tenant defendant or by the landlord plaintiff within the stipulated period as mentioned, possession will be delivered by putting the decree into execution on an application by either of the parties. Accordingly, the petitioner hearing has filed the aforesaid execution case and obtained possession. Now, the defendant opposite party is very much justified in making the prayer that in spite of getting delivery of possession on 26th of April 16, petitioner herein has neither completed the work of building rebuilding of the portion of the premises in question for putting back the possession of the tenant to the tenant opposite party, nor has delivered possession in compliance of the order of the City Civil Court, which directs that the plaintiff landlord shall put back possession to the tenant to the reconstructed building within 1 year from the date of delivery of possession. The plea taken by petitioner is that.
No, I know that. The fact is clear.
Fact is clear. And paragraph 12,
only the petitioner has approached this court only on the point that the decision taken by a coordinate bench. In the view of the petitioner, it is
in violation of the Supreme Court's order.
Of the order of the Supreme
Order of the Supreme Court.
This is the only ground.
Only ground. The other ground is jurisdiction.
Other ground
no, jurisdiction. He has argued jurisdiction, 18 capital A. That jurisdiction is not there. The entire proceeding is bad.
The decision was taken regarding the jurisdiction also taken care of by the coordinate bench also.
My lord.
Only the petitioner approached this court that the order of the Honorable Apex Court was not followed by the coordinate bench.
Now,
whether this court can entertain. This is the only issue.
Now, my lord, the question is, my lord, if he is aggrieved by this previous order, his only remedy was to go before a higher forum, which he has not gone. So he has accepted this order. Today, he cannot say this order is contrary because what is the forum, my lord, for taking this point? If the Honorable High Court directs that yes, execution is maintainable, you file a separate execution case. Only forum is, my lord, only forum is the Honorable Higher Court, which he has not gone to. So this is a clear case of res judicata. Clear case of res judicata. If it is a case of res judicata, my lord, he cannot raise the issue. Good, bad, indifferent, legality, illegality, he cannot raise the issue at all. If your lordship not takes the language of section 11, can he raise these issues? On merits, I will satisfy your lordship because the Honorable Supreme Court's order I have placed before your lordship. Honorable Supreme Court does not say that executing court cannot or civil court cannot pass the order. Specific direction has been given. I've shown paragraph 14 that tenants are to be put back in possession and the civil court will ensure that. And if they do take devious means, they shall be put down with iron hand. That is the observation. So on merit also, my lord, on merit also, his submission that the Supreme Court order is violated is incorrect. And the Honorable High Court has given reasons why. Because from the Supreme Court up to the decree, he has not challenged the decree also. Decree is a two-sided decree. Decree was passed in terms of the Supreme Court's order. I have shown your lordship.
Okay.
So, my lord, so this is the position, my lord.
Yes.
Both the points fail. Res judicata, language is very clear. No court shall try any suit or issue in which the matter has been decided. So this he cannot raise this issue at all. For my lord deciding whether this order is in violation of the Supreme Court's order, he has to, my lord, raise the issue. Your lordship will have to decide it. Section 11 bars that. No court will decide an issue. So, my lord, he cannot take this issue today. And secondly, I have satisfied your lordship on merits also that no, there is no violation. Article 142, Article 141, whatever be the, my lord, point taken by him, the Supreme Court has taken care of the tenants. And so this is the position, my lord, nothing more, my lord. Because I say, no. I say, my lord, that now he cannot, so it has to be, my lord.
Why such 6 matters?
Because various orders have been challenged.
4 separate matters, 4 separate matters, or 4 separate applications there. Two applications, your lordship, those are pooled matters of 2024. Initially, we challenged 2 orders in 2 applications. That could not be heard of. It was pending. So when these applications, 3 applications are released by the Honorable Court, we mentioned that these are the matters pending before lordship. So his lordship was pleased to release it.
What is the point in all the matters? Same point.
Same point. Same point. Jurisdiction of court.
The maintainability of the proceeding initiated by the landlord, by the tenants.
Yes, lordship.
You say it is divorced to the provision of 18A.
18A.
This is your ground. And 141 is there.
Yes. And another thing, only one thing I will submit. My learned friend has finished. My lord, my learned friend has referred to your lordship that paragraph 15 of the Honorable Supreme Court judgment, wherein there's a formal decree and consequential orders of the tenants being put back in possession in the reconstituted building. Nowhere in the judgment and decree passed by the Honorable Supreme Court had stated to violate, to do whatever you do, but that should be within the binding or within the 4 corners of the provision of Section 18. Can you
not been stated like that?
Well, kindly, your lordship, the last portion of it, being put back in possession in the reconstructed building as directed above in terms of Section 18.
Yes.
Nowhere in the judgment and decree passed by the Honorable Supreme Court has.
So you see the last paragraph
Yes, your
of
lordship.
the Honorable Apex Court?
Yes, look into it, your lordship.
All consequential petitions can be entertained by the petitioner.
As per Section 18A.
No, not as per Section 18A. Yes, you go to the 18A. That
15,
is
my
after
lord.
completion of building.
My lord, kindly, your lordship.
That is
My lord,
after completion of
paragraph.
Admitted case is that it is not complete.
So paragraph 15, your lordship, take paragraph 15.
Yes.
And page 23. Page 23, inner page 23.
Yes.
Yes. Interest of the tenants and will ensure that all the building laws are respected by the landlord while constructing. The modified plan will be produced by the landlord before the trial court so as to enable the court to pass formal decrees for eviction and consequential orders for the tenants being put back in possessions in the reconstructed building as directed above in terms of Section 18. So 18A, the provisions, Supreme Court never directed the parties or allowed the parties to violate.
From section 18A, you
Yes,
read
that's-
section 18A,
Yes, Lordship.
that is very clear after completion of building,
Yes, Lordship.
not before that.
Yes, Your Lordship.
Statute is very clear.
But whether that, Your Lordship, whether that alone allows the small causes court to acquire the jurisdictions to deal with it,
You need that. You
to
direct
proceed, Your Lordship.
to expeditiously pass decree and consequential order.
Consequential order.
Yes, consequential.
Terms of
In
section
18A,
18A of
yes, Your
that.
Lordship, yes. But
Consequential
whether
order for
Trial court was directed.
for the tenants being put
Provision
back in possession.
18A, read 18A.
Yes.
18A subsection 1 is there for
Yes.
the trial court.
Yes.
Subsection 2 is for the
18, my lord, section 88, 18A doesn't speaks of anything about the tenant, the landlord filing an application for execution. As we did. Initially, we had to move before as per the direction of the Honorable Supreme Court, we moved before the city court as being the trial court. Then the decree was passed. My lord, whatever be the decree passed by the city court, my lord, there's a consequential orders to be passed there, but that cannot supersede the judgment and findings of the Honorable Supreme Court. That is it.
Understand. So
That is
now
it, Your
what happened? Now you have approached this coordinate bench. The coordinate bench has passed a decision on that point. So you again appear before this court
Yes, Lordship.
on the ground that the coordinate bench has violated the order of honorable appeal.
Yes, Lordship.
Whether this can be entertained.
My lord, I placed, my lord, the judgment I had referred to
Yes.
as per 141 and Article 142. My lord, if your lordship find there is any anomaly, if there is any contradictions, then your lordship may refer the matter before a higher forum. My lord, the judgment is pretty pat on the point. I had stated that. Only paragraph, I think paragraph 10, I think. I stated that. If your lordship finds
Same matter.
That this issue can be again agitated before this court.
issue, my lord,
Difference,
that's being,
difference on
my
different
lord,
matter.
issues being decided by the Honorable Supreme Court. That is still remaining as it is.